This call is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the meeting over to the ACCV Chair, Mr. John Howie.
Good morning, everybody. I appreciate everybody's patience. We were having technical difficulties, and I think we are now up and running. So thank everybody for being here today. I'm going to make my comments short so that we can get this thing moving along. I'm basically a carton of milk that's been sitting in the refrigerator for 3 years, and I expire today. So this is my last meeting. I am looking forward to it. We've got a lot of great speakers lined up to present to us. It's a bit of a revisit to our May meeting, but it's different because this time, instead of just listening, we get to ask questions. And I'm excited to have an open dialogue with the people that have been kind enough to come talk to us today about the subjects that they're going to be discussing, and I'm looking forward to it. So with that, I guess we need to do a roll call. Is that right, Tamara?
Yes, John, we do need to do the roll call first. Yep.
So I'm here.
Okay.
Barbara?
I'm here.
Thank you for joining us today. Bill?
Yes, hey, John.
And Karen, are you here as well?
Good morning, everybody.
Okay.
All right, so I think we're all here with bells and whistles and ready to move on to public comment. How about that?
Yep, that's fine. Yep. So, operator, are you open up? Can you open up the lines for public comments on the agenda?
If you would like to make a comment, please press *1 on your phone and record your name. There you go.
Hello?
Our first comment comes from Teresa Rangham. Your line is open.
Good morning. My name is Teresa Rangham. I'm the Executive Director for the National Vaccine Information Center. I want to thank the ACCV for creating a robust schedule today, agenda today. In terms of comments on the agenda, the presentation on the VSC, the update from ISO, I would just say it would be nice to know how duplicatable that information is to independent researchers and statistically powered, and just that research cited to the ACCV. The guidelines suggest that funding and source be identified as they're presented with information. Thank you.
Ms. Operator, do we have any more public comments on the agenda lined up?
We have no other comments at this time. Again, to place a comment, it's *1.
Tamara, I'm inclined to get us back on track and say let's move on to approval of the minutes.
Sure.
Okay, let's
There
do that.
is one comment
Oh,
that's come in. One moment.
thank you.
Jimmy Hodges, you may speak your comment.
Yes, I had a major vaccine injury, SERVA injury from the pneumococcal polysaccharide vaccine, not covered under the SERVA table, and I wonder if y'all could have some discussion on that. Tried to do quite a bit of research and found that 50% of the vaccine injury claims are SERVA claims, and 99% of those are adults. I was wondering if y'all could try and get my vaccine covered make it retroactive possibly for 3 years, because I'm not having any luck, and I had a major injury and have had surgery 6 months ago, and I still don't know if I'm going to recover 100%. And I'm having to pay all my medical bills, not getting any compensation, have no nobody on the line as far as right now trying to help me. So I was wondering if maybe y'all could suggest some help on finding an attorney, or if y'all could possibly get this thing approved and get it retroactive. Thank you.
Mr. Hodges, thank you for your call, and thank you for your comments. And it's certainly something that I think that can be considered for future agenda items. Thank you.
There are no other comments. Thank you.
All right. Well, then I think with that, let's go ahead and move to approval of the minutes. I've reviewed the minutes. They look good to me. Barbara, Bill, Karen, do you guys have any concerns or issues about the minutes?
Nope.
Nope, nothing from me.
I second that approval.
Yeah, I was going to say, then I'm going to move to approve the minutes.
So all,
Second that.
so
There
all
we
in
go.
favor? Everyone's in favor?
Yes.
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 Okay. Any opposition? Okay. Minutes approved, right?
I would agree.
Okay.
And Tamara, I think you're up.
Yeah, so just waiting for my presentation to load up. So
You should be seeing it now, Tamara, no?
nope, don't see it yet.
I do see it.
Yeah,
I
no,
see it.
I'm not. Yeah.
So are you still just seeing the agenda?
I'm not seeing anything. I am just seeing a blank screen, so I don't know if I need
Me
to.
too. I see a gray screen.
I can see it. I don't know if you want to try to close the program then. Maybe for some reason it
Okay,
froze
let
or
me.
stopped working for you guys. Cause
Yeah, let me try it, and I'm gonna go out and come back in.
Okay.
I'm logged in through Adobe Connect. I was online, and then it asked me to go through Adobe Connect. Should I just go back online then?
No, you should be in Adobe Connect.
That's where I'm at.
We've had a couple people say that they've gone out and gone back in, and they can see it. And our
Yeah, I did.
Adobe text just said if you're unable to see the document, please log out and log back in using the Adobe app.
Still not seeing it. I went out and come back in. Let me try.
Okay, so now it's asking me for room content link to get back in there, even though it did it automatically before. I'll use whatever's on the agenda then?
Yes, you should be able to join using the agenda.
You know,
Well, I'm back on the website, not on the Adobe Connect, so. All right, I'll go to the website.
yeah, Annie, I'm still not seeing it either. I still need to, let me see.
Okay, Tamara, if you go to the ACCV website under the
Yes.
December 3rd meeting information, if you click on the webinar link there, it should.
Okay.
I just joined and
Okay.
didn't have any problem doing it that way.
Okay, I will do
I'm
that
back
way.
on Adobe Connect, and it's still gray. So do you want me to go to the HRSA website and then go where?
Yes, and then go to the I'll send it to you real quick, Barbara. Do you have access to your email or?
Yes, I have my email.
Okay. Yeah, if you just go to the ACCV website.
Yep.
And then it should, under meetings, it should say December 3rd, and there should be a link there to join the webinar.
Okay. In the webinar. Yeah, that's the same webpage I keep going to. And it keeps sending me to the Adobe Connect app where I keep seeing a gray screen.
Same here, Annie. So I guess, you know what I will do? I will just pull up the presentation that I have and just,
I'm just going to continue in browser, okay? Because I can see it in the browser.
Okay. Tamara, I can advance your slides. I have them up, so whenever you're ready, you can just start.
And Tamara, you can just say continue in browser and ignore the Adobe Connect, and you'll see it.
yeah, I see it now too. Okay. I went through the browser, Annie. For some reason, I don't know why it's not working on the app.
Yeah,
okay.
neither is it for me.
Okay, I have it. Sorry.
Okay.
So this is Tamara Overby, the Acting Director for the Division of Injury Compensation Programs, and so I will be providing our update today. Annie, you can go to the next slide. So today, during the meeting, I will, like I said, be providing an update on our HRSA VSCP activities. The Department of Justice Vaccine Litigation Office will also provide their update. We will get an update on ACCV workgroup activities. We will also have various presentations from guest speakers regarding the VSCP NPRM. I will provide an overview of the Countermeasures Injury Compensation Program, and then we will have updates from the ex officio members from FDA, CDC, NIH, and OIDP. Next slide, Annie. So in fiscal year 2020, which ended September 30th, we had a total of 1,191 claims filed this year, which is down from the 1,282 claims that we had filed in 2019. Of the 1,191 claims that were filed in 2020, 1,084 were filed on behalf of adults and 107 for children. So far in fiscal year 2021, we've had 251 claims filed for adults, 28 for children, for a total of 279 claims filed so far this fiscal year, which started October 1 of 2020. Next slide, Annie. So this slide just depicts the numbers that I just went over. You know, as you can see, the majority of the claims are filed for adults versus children, and you can see the total number that were filed in 2020. Next slide, Annie. So this slide depicts how the number of claims that have been filed compared to the amount of funding we received. And so in 2020, we did receive a bump of $1 million from 2019. So in 2020, we had a budget of $10.2 million, which was an increase of 11%. But if you look at our numbers, you can still see that the increases that we have in budget have been small compared to the increases that we've had in the number of claims filed over the last couple of years. Next slide, Annie. So as I've mentioned in the past, we do have a backlog of claims. And so as of November 30th, the backlog is a total of 1,021. 968 are for adults and 53 are for children. I will say that some of these claims are not truly claims that are ready to be reviewed because they haven't been activated by the PAR. Just to remind people that the PAR is a pre-assignment review process that the court uses to determine when claims are ready to review, that there are a sufficient number of records for the claim to be reviewed. So we do have of the claims that are here for children, they basically have not been activated by the PAR, so they're not ready for us to review. but they've been filed. And then of the 968, 278 of those have not been activated by the PAR. So truly, we don't have a backlog for children because all the claims that have been ready to, that have been activated by the PAR have been assigned for review. Next slide, Annie. In 2020, we paid out $168 million, close to almost $187 million in petitioners awards, $31 million in attorney's fees and costs. So far in 2021, we've paid almost $62 million for petitioners awards and about a little over $6 million, I'm sorry, for attorney's fees and costs. And next slide. So other adjudications that have occurred in the program, in 2020, it was determined that 706 adjudications were compensable, 194 were dismissed for a total of 900 adjudications in fiscal year 2020. So far in fiscal year 2021, there have been 94 adjudications, with 70 of them determined to be compensable and 24 dismissed. Next slide, Annie. So this slide just breaks down the categories of compensation in the program. So far in 2020 is completed, but of the 706 compensable claims, 265 were concessions, which means that HHS has conceded that the vaccine caused the injury. 47 were court decisions, and 394 were settlements. So in 2020, 56% of the claims were compensated through settlement. So far in fiscal year 2021, we've had 27 concessions, 6 court decisions, and 46 settlements. So the settlement rate is at 58% in 2021 so far. And next slide, Annie. The trust fund, so this is the balance as of the end of fiscal year 2020. It had over $4 billion in it. Excise tax revenue was $310 million. Interest on investments, close to $70 million. And the total income was $384 million, close to $385 million. And moving that to the next slide, Annie. So the trends that occurred in fiscal year 2020 are, that have occurred in fiscal year 2019 are pretty much the same as those that occurred in 2020. That 90% of petitions were filed for adults. That over 54% of petitions filed in the last 2 fiscal years are alleging SERVA as an injury. 73% of the petitions filed in the last 2 fiscal years allege an injury from influenza. 71% of petitions filed are compensated by a negotiated settlement. But as you see in 2019 and 2018, in 2020 it was like 56%. And then so far in 2021 it's 58%. And then there's nearly a 14-month wait for a petition to be reviewed by a HRSA physician. Next slide, Annie. So we are continuing to seek nominations for all of our ACCV positions, and we do have an open and continuous process to receive nominations, and these are the various categories. So please, if you know of people that are interested, please have them submit nominations to Annie Herzog at accv@hrsa.gov. And next slide, Annie. And then this is Annie's contact information. And I will take any questions if any of the members have questions.
Tamara, I have a question.
Sure.
Can we go back to slide 7?
Okay.
All I've heard about for the last, 6 months now is that shoulder injury claims are depleting the fund. But when I look at fiscal year 2017, which was the year that shoulder injury claims were added to the table, and I compare it to fiscal year 2020, it looks like that petitioners' awards, the amount awarded to petitioners has decreased $70 million. Is that right?
So in 2019, so you saying from 2017 to 2020? You mean the difference
Yes,
between
ma'am.
those 2 years?
From when shoulder injuries were added to the table in 2017 to fiscal year 2020, which is the last complete year we had, it looks like petitioners' awards have actually decreased $70 million. Is that right?
Yeah, that's what these numbers are showing.
So how is it that HHS can position for the last 6 months stating that shoulder injuries are depleting the fund when shoulder injuries don't appear to be depleting the fund? The numbers of shoulder injury cases that have been filed have gone up, and the amounts awarded have gone down pretty substantially, right?
Yes.
So what does HHS base this statement that shoulder injuries are depleting the fund on?
So, John, someone from HHS is not here to be able to answer that question because I'm assuming that you're basing it on information that was included in the NPRM, right?
Well, yes, ma'am. I took that as being true. Those are statements that HHS made. I would assume they had evidence to base those statements on. So I was just like, you're the closest thing to HHS we have today, I think.
Yes. And as you see right here in the numbers, you just pointed out, it's the amount of the awards have decreased.
Pretty substantially.
Mm-hmm.
In spite of the fact that the numbers of shoulder injury cases have gone up, right?
That we're compensating? Yes.
Did we invite anybody from HHS? I think we did, didn't we?
Yes, and no one's will be here.
Okay, but we did get an invitation to them. I wanted to make sure that that was clear.
Yes.
That they were invited to come talk to us today about this, and they still haven't come to talk to us.
Yes.
Okay, that's all. Thank you.
Mm-hmm. So are there any other questions? Okay. If not, John, you want to move on? We can move on to the next agenda item.
I do. I have to get back to my agenda. Bear with me.
So the next item is the report from the Department of Justice.
Yes, ma'am. Is Director Reeves available?
Yeah, I'm here, John.
Good morning. How are you today?
I'm fine. Good morning to you.
Thank you for being here.
Well, thank you for having me. So, Annie, are you doing the slides for me, I guess?
I sure can. You want me to go to the next one?
Yes, please.
Okay. Yeah, I got it.
Good morning, everyone. So just the first slide, or actually it's the second slide, but the first part of the presentation just shows how many petitions were filed between August 16th, 2020 and November 15th, 2020. So there were 411 petitions filed, and as clear from Tamara's presentation, most of those petitions were filed on behalf of adults. Next slide, please, Annie. And then adjudications of petitions during this reporting period, there were a total of 219. 166 of those cases were compensated, and 53 of those cases were not compensated or dismissed. As you can see from the slide, most of those cases were resolved via a negotiated settlement, 105 of the cases that were not conceded by HHS. Next slide, please. And then the total petitions that were voluntarily withdrawn during this reporting period was 6. Next slide, please. This slide lists cases decided by the U.S. Court of Appeals for the Federal Circuit and Vaccine Act cases during the reporting period. The first 4 cases were appeals by petitioners, and then the one petition for rehearing en banc that was made by respondent was denied. Next slide, please. And then we have 6 cases pending at the Federal Circuit currently. These were all appeals filed by petitioners. Next slide. And the respondent has not filed any appeals at the Federal Circuit during the last report. Next slide, please. And then this is the list of the cases that have been decided at the U.S. Court of Federal Claims, which is the first level of appeal in our cases. These were all appeals filed by petitioner. I believe this is continued on the next slide. I'm wrong, sorry. And respondent did not file any affirmative appeals to the Court of Federal Claims during the reporting period. Next slide, please. And then we have a number of pending appeals at the U.S. Court of Federal Claims filed by petitioners. And this is the slide where the list is continued onto the next slide. And as noted on the bottom of the slide, any of the cases that are listed in yellow are new since the last reporting period. Cases often remain pending for a long period of time before they are resolved. And respondent did not file any affirmative appeals at the Court of Federal Claims during this reporting period. Next slide, please. And then we have 2 oral arguments scheduled, one on December 9th in the Delosier case at the U.S. Court of Federal Claims, and then one in the Orlowski case, which is at the Federal Circuit on January 6th. Next slide, please. So the following series of slides just shows adjudicated settlements during the reporting period, starting with the case that took the longest to resolve from the time the petition was filed until the settlement, the stipulation of settlement was filed, ending with the case that was resolved most quickly. And I think there's 5 or 6 pages or 5 or 6 slides. And you can see from these this information that most of the cases involve SERVA or GBS. Which has been an ongoing trend. And then this is the appendix that has a glossary of terms. And a flow chart of petition processing within the Office of Special Masters. And levels of appeal in Vaccine Act cases. And this is a flow chart of how the appeals process works in Vaccine Act cases. I think that's it. And I'm happy to answer any questions if there are any.
Does anybody have any questions for Director Reeves?
No, I don't.
I have just a couple of questions, but mine are pretty simple. During the last meeting, and I've been asked to ask this question. Certain lawyers that do what we do for a living have had a hard time locating these opinions that are referenced in the DOJ presentations, and I've been asked if I would ask if it would be possible to have the citations added to these slides in the future so that these cases can be found a little bit easier.
So I believe the same question was asked at the last ACCV meeting, and
yes,
I'm assuming, John, that you're referencing the decisions at the Court of Federal Claims and the decisions at the Federal Circuit?
Yes, ma'am.
So I guess my question to you, and I know you say someone asked you to ask that question, is I don't understand if you're a practicing attorney why you wouldn't have access to Westlaw or Lexis or a law library where you can search for these decisions, which are all published.
Right. I think part of the problem is especially with the cases involving children when they're listed with just initials, and some of these have parents that are acting as next friends for the children, for example. So if you don't have the parent's name, it becomes harder to find these cases. And unfortunately, you know, as I believe you probably are aware, the system for locating vaccine injury cases is not as unified as it is for non-vaccine injury cases, or at least that's been my experience. But I think it's primarily the issue of, you know, just having initials makes it difficult to locate these opinions.
Well, again, my understanding is that the case caption has been redacted to initials to protect the privacy of the minor petitioner. That is the way that the case is reported to the federal claims reporter and the federal reporter that reports the Federal Circuit decisions. And plus, all of these decisions are reported on, all of the Court of Federal Claims decisions, including special master decisions, are published on the Court of Federal Claims website, and on the Federal Circuit's website. All of the Federal Circuit decisions are published there, and they are searchable by name and or case number. So again, I don't understand how a practicing attorney would have difficulty finding these cases.
Well, maybe we could just put the case number on then. I mean, again, you could have, I'm looking at one of these appeals, it's LP versus HHS. LP may have a parent named John Smith, and so it would be John Smith on behalf of LP versus HHS, and you would never be able to know that it was John Smith by the initials LP.
Well, we'll certainly take that into consideration, John, for future presentations.
I appreciate that. And the only other question I had was the oral arguments that you referenced, I think on slide 13, are those broadcast online where you can listen to them, or for privacy reasons, or are they not broadcast?
The Court of Federal Claims arguments are not publicly available because the cases are point. I also do not think that you can listen in. Well, no, I'm not sure. I think Federal Circuit arguments, I think you can call in, and I think the call-in information is available on the Federal Circuit's website. So those arguments are open to the public, but not the Court of Federal Claims arguments.
Thank you. I appreciate that.
You're welcome.
Just kind of thought it might be fun to listen to some of these.
You're welcome. And also, I'll point out that the all arguments of the Federal Circuit, even under normal circumstances where everyone shows up in person, are recorded and are available after the fact on the court's website.
Okay, that's great. I appreciate that. Thank you.
You're welcome.
Does anybody else have any questions? I think that we can probably move on to our next subject. How about that? Director Reese, thank you for your time.
You're welcome. Thank you.
So as you guys are all aware, we have a work group. The work group is a little bit short-staffed right now because we only have 4 members on the commission, but we do still meet and try and move things along so that we can present them to the commission as a whole. One of the topics that we've been working on, and this has spanned a number of meetings, is the vaccine information sheets. I had a concern about the language within the vaccine information sheet and whether or not it adequately conveyed the urgency that people need to act with in terms of pursuing an injury claim if in fact they believe they've been injured by a vaccine. And so we, as a work group, have been working on revising that language, and this slide here presents the current language and then what the work group put together as proposed language for the ACCV to consider in terms of making a recommendation. Did I say that right, Tamara?
Yes, John, this is what you all as a work group would like to propose. The changes are in red in the proposed language.
Yes. So my concern was there is a statute of limitations on vaccine injury claims. If anybody has ever taken a look at it, it's kind of convoluted because there are different limitations that apply depending on whether or not you have an injury claim versus a death claim. It's also a little bit vague in the sense that the statute of limitations under a vaccine injury claim runs from the date of the first sign or symptom of an injury, which can be a topic of dispute as to, what was the first sign or symptom and when did it occur. And so what I thought is maybe the best thing that we could recommend would be to put the absolute shortest period of time that a claim could ever be into the proposed language for the vaccine information statement. And that's what we came up with here to include, was that claims regarding any alleged injury or death due to vaccination have a time limit which may be as short as 2 years, period. Because that, I think, is consistent with the law. So that's our proposal. And Tamara, I don't know where to go from here. Do we?
So you can open it up. I mean, if members have questions, comments about this proposed language, you can open up the floor to have discussion about it.
The floor is open.
John, this is Bill. I actually have a quick question about that.
Yes, sir.
The words that were struck out from the date of vaccination, why was there a decision to take that out?
I have the same question. This is Barbara, and I'm not a lawyer, so maybe there is a reason behind it, but I'm lost there.
And quite honestly, I don't know. Maybe Tamara can remind me.
John, you just actually said it, because remember the statute of limitations start from the first manifestation of a symptom. It's not from the date of vaccination. None of the time frames start from the date of vaccination. They start from the date the first symptom appears or the manifestation of a symptom.
So should we say 2 years from symptom onset?
Well, that was what I thought we were trying to avoid. And that I'm sitting here, Tamara, and I just don't remember removing that because, at the end of the day, it may be as short as 2 years from the date of vaccination. It's not going to be any shorter than 2 years from the date of vaccination. And it may be as short as 2 years from the date of vaccination.
But then if you say from date of vaccination, if you talk about time frames and date of vaccination, it's not accurate because that's not what the legislation says. It's not from the date of vaccination. John, I totally understand what you're saying, that it could be, if you shrink it down, then to say that if you base it on the date of vaccination, that's of course more like, it will be sooner than the first symptom or manifestation. But technically that's not correct. And so.
But we're not saying it is. We're saying it may be. It may be as short as 2 years from the date of vaccination. If the symptom manifestation is the first day of vaccination, then it's 2 years from, and you die, it's 2 years from the date of vaccination.
Yes, if you die.
Right, but that's what I'm saying. I think I agree with Bill and Barbara that it should probably say, which may be as short as 2 years from the date of vaccination.
Yeah, just to chime in as the other lawyer on the committee, I think that whenever it comes to the statute of limitations, anybody looking at this, whether it be an injured party or counsel, always the shortest possible window is nice to see. I think, and so as John said, I mean, something could happen the day of the vaccination. The shortest possible window anybody would ever have is 2 years from the date of the vaccination. I think by adding the word may be, which is in there, it kind of opens it up, that it could go beyond that.
And I'm not a lawyer, so I will defer to whatever the lawyers on the call are saying about that. But from a clinical standpoint, if you have not presented signs or symptoms of injury in 2 years, you don't have it. So I think it's safe to say that. Does that make sense?
Yeah.
Nobody would develop an injury, a shoulder injury 2 years out. That wouldn't be related to vaccination.
Yeah, but it's not all shoulder injuries. I mean, there are a bunch of neurological injuries that happen to children that may not be picked up for the first 2 years. I'm just saying.
But, I mean, they might be diagnosed 3 years out, but if the symptoms are there within 2 years, then that's still allowable, correct? We're not saying that, I mean, what I'm trying to say clinically is if a symptom presents 2 years after vaccination, it's not related to the vaccine. If you're saying the diagnosis is made after, that makes sense. But if the symptoms were present before 2 years, that would still hold, correct? that's where we're confused, because I agree that if something happens, let's say 6 months out, but the diagnosis is not reached until 3 years later, what is the legal implication here that they can file within 2 years of like knowing, or does that make sense? I'm lost in I know the medical piece, but I'm lost in the lawyer piece.
The statute of limitations in the vaccine injury program is an issue that we've actually discussed in the work group in terms of making a proposal to the Secretary about maybe supporting a change in the statute. The statute of limitations is the first sign or symptom. And once that first sign or symptom occurs, whether it's under the current state of the law, whether that symptom is recognized or not, once it occurs, the clock starts ticking. And if you don't get your case filed within 3 years for an injury case, or 2 years for, well, it's 2 years from the date of death, but if you don't get your case filed within 3 years of an injury claim, then you're out of luck. And that's even if nobody really recognized the sign or symptom when it occurred. So I mean, again, all of this kind of comes back to this concept of trying to communicate to people what
Should
the
we
absolute...
say from awareness? Would that help, from awareness instead of from the...
Well, but that's what we were trying to eliminate is the vague application of the statute of limitations in the vaccine injury program by telling people, look, this is the absolute least amount of time that you may have under the law. And that absolute least amount of time was maybe as short as 2 years from the date of vaccination.
Got it, yeah. Whatever you guys, from a law point of view, think, I think that's what should stay, because to me, the clinical piece of it is different. And I think what you're saying makes sense to me.
Well, and I think it needs to be added here that the clinical piece may be there, but the parent doesn't even know that there's a program, which is a whole other issue, but it's very much correlated to what happens to families.
But again, the problem I have there is the parents should know, because they were given a VIS when they were given the vaccine. It's there. So
they're supposed to have that. They're not always given that. I mean, there's many, I know parents, but it's supposed to happen. You're right.
No, I mean, we cannot administer a vaccine without giving that piece of paper. What happens if people don't read it? So it's hard for us to enforce people reading that, but it's always by law handed out. We cannot administer a vaccine without giving that. So the problem we have here, which I don't think any of us on this committee can do anything about, is the information is being given to parents. Parents are not reading it. And I am guilty of that too. How many times have I been giving documents to sign about a new car lease, and I don't read all of it. Let's just be honest. I know the lawyers do, but those of us humans who are not lawyers, we skip all that stuff. We do. So parents are aware of it. I mean, they're told about it, but it may not register. What do we do to make them more aware? I don't know, but the information is right there on the VIS that they get. So the problem is the awareness of the information was handed to me. I just didn't know about it. That's the sad truth. That's the reality.
So, Tamara, I think I'm going back now and I'm looking at my emails that we had on this subject, and at one point we had a slide. This is October 7th of 2020. There was a slide that was circulated that had that language in. I don't know why that language was struck out for purposes of today. And I understand what you're saying, but I respectfully kind of disagree, because if you say maybe as opposed to is, then I think that satisfies your concerns about how this jives with the statute, so to speak.
Just from a program perspective, I get what you're saying. I will just, and it's up to you all to decide, but I will just say that it's not quite accurate. But I totally understand what you're saying. You're saying basically, because I get that you're saying that, yes, this is potentially the shortest amount of time if for some reason a parent does, or an adult who receives a vaccine and they feel like they're immediately injured, then it's from the date of vaccination. But it will be from the date it's still from the date of the first symptom. So I get what you're saying. So from a program manager perspective, adding from the date of vaccination is not quite accurate. It's not accurate. But, okay. You all can choose to vote on this language and have that as your recommendation.
Well, I think I would like to vote on it. I would propose that we have it read as it does, include from the date of vaccination, because I think that when you say that it may be as short as 2 years from the date of vaccination, I think that that's accurate, and I think that's the shortest possible period, and I think that conveys the message that we're trying to convey to people, which is you've got a limited amount of time, and it could be as short as 2 years. So if you're going to do something, get doing it. So I would vote.
I agree, John.
That would be my vote.
I agree.
Yeah, I would agree with that as well. Hey, one quick question. I know there's a link in the sentence following that language. What if that sentence directed anybody reading it to the actual language of the statute? So, for further information on the details of the actual statutes of limitations governing death or injury, follow this link. I don't know, or maybe that's convoluting the situation.
So
I think
guess that could be an approach, but the other issue with that is a lot of times this is not being sent to people electronically. But because if they go to our website, they'll see the actual statute of limitations language is on our website. So that next sentence will take them there. But I guess if you all wanted to add language to say that, I don't know, for more details on the program statute of limitations, visit the VICP website. So that would be up to you all.
Bill, that link that's there, if you cut and paste it into a browser, it takes you to kind of a question and answer page about the program that has a link that says who can file a petition. And under that link, it has the filing deadlines kind of spelled out in more detail.
Okay, that's great. That works.
So, John, it's up to you all if you want to take an official vote, because it seems like,
I do. I think we should, because I think we're there.
Okay.
I would vote in favor of the language with the inclusion of from date of vaccination.
This is David Kim with the Office of Infectious Disease and HIV/AIDS Policy. That's within the Office of the Assistant Secretary for Health. If I may comment, the agenda does not include a process for a vote. The agenda indicates that a discussion will take place regarding the revised statute of limitations language on the BIS, and no proposal for an open dialogue on this. Now, I understand that the committee has met and discussed the issues, but no discussion on besides what we're seeing on the screen right now. No discussions on the thought process, the justification, the existing situation, and the proposed language and alternatives to the proposed language have been discussed. And I might propose that for sake of transparency and openness, that these discussions actually take place before a vote is taken, and if a vote is to be taken, that should be on the agenda.
So David, this is Tamara, and I understand what you're saying, but this is a discussion. That's the purpose of actually presenting the current language versus the proposed language, and the members are discussing it in a public forum. So that's what's happening right now, and so they can take a vote at this point in time.
I mean, do we need to add it under new business?
No, Karen, you all can take a vote now, because this is your discussion that's occurring right now.
Okay.
Because you are presenting you're presenting the current language, proposed language, and this has been and also this has been a topic of discussion in previous ACCV meetings. That's how we've gotten to this point where we are now.
Exactly.
That you all have suggested that the language be revised in previous meetings, and the work group was charged with coming up with proposed language, which you all have, and you coming back to the full ACCV and presenting it, which is what you're doing now. And so now you can take a vote.
Thank you.
Mm-hmm.
I vote for it. I agree with John.
And I, in which case, the I will just say that perhaps the agenda should have included that. But you don't have to comment on that, so I defer to the committee members proceeding with the process.
Okay, John. So if you want to you manage the vote, that's fine. So you want to go ahead?
I'm sorry, say that again.
No, John, so you can take a vote. You can have the committee to
Yes,
take
I
a vote.
thought that I made that clear. I would like to take the vote.
Okay.
We've been discussing this in various phases for 3 or 4 meetings now in terms of the VISs and the language on the VIS. And what we decided to do a few meetings ago was to roundtable this in the work group and come up with a proposal that we would present to the ACCV, and this is the proposal we came up with. So I think that it's time to vote.
Okay.
And I'm in favor. Karen?
I'm in favor.
Dr. Pahood? Barbara? I'm sorry.
And is that in favor as it's written with a strikeout? Then yes. Or are we saying in favor based on edits?
In favor with the language included from the date of vaccination.
I'm worried about adding from the date of vaccination because we are being told by Tamara that seems misleading. So I think the 2 years is fine with me, but I'm not going to, this is a battle I would not fight. I'm just trying to be correct, and I don't know the nuances of it. So I think if we say claims regarding alleged injury of death due to vaccination have a time limit for filing, which may be as short as 2 years, if everybody's okay with that, I'm okay with that. If you guys think it's correct to add the from date of vaccination, even though she's telling us that's not strictly speaking correct, I'll defer to the group, but I would go with what seems more correct. So I think the way that it is right now, I'm okay with it.
Bill?
I'm in favor of the language as is, including what had been struck out from the date of vaccination.
Okay. So we will record that vote. All right. So want to move on to the next agenda item?
Yeah, and just very quickly, just so everybody is aware, we also discussed at the last meeting re-urging our recommendation to the Secretary to support an increase in funding for all phases of the program, the court, DOJ, HHS, as well as the Secretary supporting an increase in the number of special masters. Tamara, I believe I'm correct in saying that that letter has been finalized and is being sent. Is that right?
I don't think so because it hasn't been signed by both of you all, I don't think, right? Annie?
I
I
sent my
signed it
signature
yesterday.
Okay, all
I
right.
signed it.
Then it hasn't, well, it will be
So
sent.
that's a box that we can check as well. I just wanted to make sure that Barbara and Bill, you guys were aware that that was done. And at that point, I guess we can move on to the next presentation, which would be Mrs. Wrangham, if she's available.
So Jonna, we would just want to let people know that we're moving into the section of the agenda where we're going to have presentations and discussions from to get different perspectives on the VICP and PRM. And so Teresa Wrangham is the first person, right?
Yes. That's
okay.
Yep, that's correct.
Okay. Okay.
Is Ms. Wrangham available?
So, operator, could you allow Teresa Rangham to be a speaker?
Operator?
Teresa just messaged me. She's trying to get on. I guess that they haven't made her open to speak
Yes.
yet.
Hello?
And this is
Hello?
the operator. Teresa's line should be open now.
I think I'm echoing. I'm going to turn my speakers off. Can you all hear me okay?
Yes.
Yes, ma'am, we can hear you fine.
Okay, thank you. Lots of technical glitches today. Well, first, I'd like to thank everyone for the opportunity to give perspective today. I don't have a mechanism, I don't think, on Adobe to advance my screen. So, Annie, I hope you'll do that for me.
I sure can.
Thanks so much. My name is Teresa Rangham. I'm the Executive Director for the National Vaccine Information Center, and I'll be providing a consumer perspective from the standpoint of an organization of standing. And I just appreciate the opportunity to provide this comment today. Advance? You're gonna, thank you. Just a little bit of background on why we're an organization of standing. We started out as dissatisfied parents together, and we were asked to come to the table by Congress, members of Congress, Senators Kennedy and Waxman, to sit down and help craft what vaccine injury compensation would look like when the vaccine industry had threatened to leave and our nation decided that we needed to secure vaccines for our nation. So we were a part of the drafting of the law and worked heavily with Congress to get that language into the law around compensation and help to pass the law, helped get the public behind the passage of this law. We've participated on numerous federal advisory committees, and some of them which have to do with those committees created by the Act. Go ahead. And we've been invited by the Institute of Medicine over that space and time since 1986 to coordinate vaccine safety workshops and to opine on the schedule. We've also been asked by other federal agencies to give opinion due to our standing, as well as provide opinion to the GAO on this program. Go ahead and advance. So for the purposes of today, I just wanted to talk a little bit about, from our perspective of being a consumer watchdog, if you will. We don't take a position for or against vaccines. We just believe it should be voluntary and be in accordance with the informed consent ethic, which is deemed a human right. We're going to talk a little bit about injury compensation. The original intent when we sat down at that table was to make sure that there was a process that was no fault. It was generous and expeditious, and compensated the injured in a quick fashion. Now, this was only an administrative alternative. This was never intended to be a full liability shield. It became one in 2011 with the Brucewitz decision out of the Supreme Court. Advance. It also established a vaccination plan, a national vaccination plan. Often what's missed is while we focus on this plan providing prevention against disease, it was also supposed to provide optimal prevention against vaccine adverse events. It was not one or the other, it was both. There was supposed to be equal investment in that. Advance. And we fought very hard for the research mandate wording. The intent of the law in this regard was to make sure that because there was going to be an investment by government in recommending vaccines to our nation for use, that there needed to be a commensurate investment into research to assure that vaccines would not be any more volatile or create serious adverse events more than vaccines that were already licensed at 1987, and that on an ongoing basis, we would always be seeking to refine and improve vaccines in use in the United States to assure the people that the vaccines that they had options to use were the safest and least reactive possible. Advance. So the Institutes of Medicine was also identified in the 1986 Act, and the reason we felt strongly about including the IOM within the law was at the time they were the most impartial entity out there that could do high quality reviews of the medical literature to make causality determinations. We liked their methodology of weighing both epidemiological evidence and mechanistic evidence. They've issued several reports over the course of time that this program has been in effect, and the majority of adverse events they've been asked to look at, they've been hampered by what they call inadequate science, and that defines when you look into any of the Institute of Medicine reports, they define that as either an absence of science or a lack of high quality science. So what this indicates is that we're seeing gaps in science, that this research mandate that I just spoke of, there are gaps in what we understand about the mechanisms of vaccine injury that are preventing the informing or the expansion of the vaccine injury table. Advance. There we go. So the 2012 report was the largest of its kind. It looked at either 156 or 158 adverse events, and for 85%, again, the Institute of Medicine was prevented from making causality statements. However, they did make causality statements with regard to SERVA and syncope, and they did not rule out that the vaccine was involved. They just said it was not necessarily attributable. And I think it's important to bring out this language because this is very consistent with how the IOM approaches their charge. They put these words in for a reason because science evolves, and they did not rule out that vaccines weren't involved. Advance. With regard to SERVA, what they stated was that the evidence that they had in front of them, which they list, and I have a direct quote here, but there was more than a Kennesaw look at, it only suggested that the injection was contributing to deltoid bursitis. They did not say the vaccine was not involved. Again, they never ruled that out. However, it's interesting to note that within the NPRM, we're missing the word suggest. It tends to make the IOM's language look absolute when in fact it's not. Advance. With regard to syncope, we see the same thing when we do a comparison between the language of the 2012 report and the language in the NPRM. Again, the IOM did not rule out that vaccines could be involved in syncope. They simply were speaking to the possibility of injection and saying that it suggests. Advance. So a little bit of the history that I've seen unfold, because I've seen petitions come and go and changes to the table come and go in my over decade of monitoring this committee. With regard to syncope and SERVA, the IOM's conclusion was evidence convincingly supports. That is the highest conclusion, causality conclusion language that the IOM uses that informs the vaccine injury table. When we see that sort of language used by the IOM, it is immediately taken up to be presented to the ACCV for consideration on recommending to the Secretary that it be added to the vaccine injury table. This was done in a presentation made by, I believe it was HRSA, in 2012. It was adopted unanimously by the 2012 ACCV, and it continued to be supported through presentations made over 4 years, by agencies to the ACCV, and was finally adopted into the table in January of 2017. My point in putting this bullet up here is when changes are made to the table, it's very thoughtful. The ACCV has a very large involvement, and evidence is always presented. And because this was such a large report, it took time to adopt everything into the table. Of SERVA and syncope were not the only causality findings of the IOM that were adopted into the table. Advance. So notably, from a consumer standpoint, as we look at this as a watchdog organization, this is the first time I've seen, the first time I believe our co-founders have seen this sort of process not unfold to the ACCV with presentations from DHHS on justifying a modification to the table. Advance. So in thinking about what's happened since the IOM report in 2012 to now, when you look at the cutoffs on evidence the IOM used, it's been roughly 10 years since we've looked at any evidence. And a brief scan of PubMed over at the National Institutes of Health, you would see many studies that have been published which state very clearly that there is a disproportionate, there's a huge amount of syncope that occurs disproportionately with HPV vaccine. That alone suggests that perhaps vaccines are involved and in play. And it would be advisable to do a scan of research before changing the table, given that it's been 10 years and we are seeing more evidence published in this regard. Advance. We also see additional evidence published with regard to SERVA. I also think it was very interesting to note that during previous ACCV meetings, there's been public comment by healthcare providers who do injection-related therapies into the shoulder and who, from a clinical standpoint, have also noted that they aren't seeing things like SERVA happen when they inject corticosteroids, and yet we're seeing something happen with vaccines. So I think it merits that ongoing look at evidence, but more importantly, there's nothing to suggest that erring on the side of petitioners and retaining these injuries within the VIT shouldn't be our course here. And from a consumer standpoint, we support retaining these injuries. Advance. And I've already said that, so we can advance again. I think from a historic standpoint, it's also important to note, and I think Commissioner Howley brought this up in a different sense earlier today in his comments. From a vision standpoint of the intent and spirit of this program, what was intended? It was intended that the vaccine injury table would keep pace with the expansion of the recommendations by our government for children to receive vaccines. Since that time, we've also seen the creation of the adult vaccine schedule as well. It's interesting to note that at the inception, this program worked very well. Before 1995, what we saw were 74% of petitions were for table claims which is exactly the intent, that research would chug along and provide us with information on vaccine injury mechanisms so that people who did get harmed could be compensated. And it worked. Unfortunately, we saw some of our biggest changes to the law in 1995, and changes to the table were made, and we've seen that move along through the years to the point that by 2015, only 2% of petitions were for on-the-table claims. And this, in essence, means that the system that was supposed to be expeditious and generous to the petitioner has become more adversarial. Petitioners are having to fight to prove that they're injured because we don't understand the mechanisms of injury. We aren't seeing research inform the table at the same pace as we see the vaccine schedule expand. This was pointed out not just by a report by Mary Holland, but also by the GAO in 2001 and 2014. When you look at overall claims for the program, even though we're seeing more claims compensated by fiscal year, overall, on the bottom line, 2/3 of claims are denied. I bring this up because the NPR brings up the concern that there are frivolous lawsuits or petitions being filed within the system. And what I'd point out is the system is self-correcting. There are measures within the BICP and criteria within the BICP to make sure that petitions with no merit or that don't meet criteria are dismissed. So the concern that somehow SERVA and syncope petitions wouldn't be caught in that same process doesn't seem valid. We've already noted today, through today's reports, that children are very rarely compensated today. This is another change that has been brought about by modifications to the table. Advance. And the GAO in 1999, as far back as 1999, noted that changes to the table have had the adverse impact of making it harder for petitioners to get compensation. It's not erring on the side of the petitioner anymore when you have 2% of people only being able to file a table claim. Advance. So just to sum up I'm sorry, my screen just went blank. Hang on, I can't see my slide. Just to sum up, I just wanted to say from what we're looking at from a consumer standpoint, we've seen the public overwhelmingly come out during ACCV meetings to support retaining these two injuries, and that the trust can actually support it. Commissioner Howing mentioned it in one regard today, but I would also point out the GAO has issued a report previously that notes that the trust fund, that the table should be expanded because the trust fund was building up in funds. And to see today's report noting that more claims are being compensated, yet less money is leaving the trust, and the interest earnings competing well over what we see in the excise tax contributing to the trust. I don't think there's a valid worry at this point of syncope and SERVA draining that trust fund. Advance. We've already been over this point. There's already a process to exclude claims without merit. I would say from a removal standpoint, it really conflicts with the original intent of the Act. It reverses expeditious compensation. It's going to increase costs on behalf of attorneys who are now going to have to take this up as a off-table claim, and it certainly isn't going to provide relief to any caseloads because they're going to stay on, in terms of length of time within the system, a longer length of time than if they were admitted into the system as a table claim. And when we added SERVA and syncope to the table, that 2% ceiling lowered. It's going to go back up. If we don't retain these injuries, it will simply go back up. So I guess what I'm saying from a consumer standpoint is watch this process since its inception. There's room for improvement in terms of ongoing research, to do high-quality research and independent research that the IOM can look at to inform the table and expand the table to meet the intention of what this program can do. We saw it do early on, and it would relieve caseloads over at DOJ as well to see this more expeditiously processed. So I appreciate the opportunity to offer this point of view. Thank you.
Ms. Rangham, thank you very much. It's very informative to get to see all of that information that you presented, starting from the inception of the program, all the way up to the present. So we appreciate that. Does anybody have any questions for Mrs. Rangham? I hear silence. Am I still on the phone?
I have no questions, but thank you, Teresa.
I didn't know if Tamara had hung up on me.
I have no questions. I muted my phone because my dog was barking, and I figured you didn't want her opinion.
Well, we can get her opinion.
No, John, I'm still here too.
Okay, all right. Ms. Rangham, thank you very much. We appreciate you presenting today, and we always enjoyed hearing from you. Thank you. I guess at this point we're due for a break, and we're running a little bit early. So, Tamara, what would you like to do?
So, Amber or Annie, because I think the reason why I'm pausing here is because is Christina available now? Because I know we were reaching out to her.
She is online and available now.
Okay, so then it's up to you all, John, as a group. We could go to the next presentation and take a break after that, since
Yeah, that's fine with me.
Okay.
If she's available, that's okay with everybody else.
One quick question. I do have to answer some patient calls. Can I get a sense of when the break is so I can text people and tell them when I'm going to be calling them back? I just need to know the window, basically, of when we have the break. Because, I'm using my phone for this call, so I can't call anyone while we're on this call.
So, John?
Yes, I would think if Christina is ready, we can probably get through her, and I would think we would be breaking in no longer than 30 minutes, certainly probably closer to 20.
Yeah,
right.
20 to 30 minutes, we'll have a break, and can you let me know how long the break will be? Just ballpark.
How long do you need?
Probably 15 minutes to answer all the calls that I've accumulated.
Oh, we can do that for sure. Maybe
Okay.
30 minutes? I mean, does that work for everybody else? I'm game. I'm open all day.
Yep.
Yeah, currently
Yep.
you guys are scheduled to take about a half an hour break. So whenever that starts and begins is fine.
Perfect. Thank you.
Okay, if Christina's ready. Christina is the current president of the Vaccine Injured Petitioners Bar Association. That is a group of lawyers that represents people who have alleged that they have suffered injuries as a result of vaccination. So, Christina, if you're ready, we'd love to hear from you.
So, Annie?
Yes. Operator?
And this is the operator. Christina, if you don't mind, would you please press *0 so we can open your line? Again, that is *0. Thank you. Okay, Christina, your line is now open.
Thank you. Good afternoon. Can everybody hear me now?
Yes. Hi, Christina.
Yes, ma'am.
Before you get started, did you want either one of your letters up for viewing during your talk?
I don't think that's necessary. If you have them in front of you, I certainly am happy to answer any questions about them, but I'm not going to follow along in a point-by-point slide.
Okay. All right. Just making sure. Thank you.
Thank you both so much. I thought that Ms. Wringham's presentation was very comprehensive, and I will do my best to not duplicate much of what she said. But by brief introduction, as Mr. Howie said, my name is Christina Ciampolillo. I'm an attorney who represents vaccine-injured petitioners in the NVICP. My firm practices exclusively in the program and has done so for decades. I am also the current president of the Vaccine-Injured Petitioners Bar Association. As you know, the Secretary's Notice of Proposed Rulemaking aims to remove two specific injuries, CERVA and syncope, from the vaccine injury table. During the ACCV's May 2020 meeting,
Can I stop you for a second? Are we supposed to be seeing slides? I'm still stuck in the thank you from the National Vaccine Information Center. I just wanted to double check.
No, my submissions were in the form of letters, not slides.
Okay, great. Thank you. Just checking.
Thank you. So during the ACCV's May 2020 meeting, following the public comments, the ACCV members discussed the Notice of Proposed Rulemaking. In listening in, it appeared to me that some members had questions as to how CERVA and syncope were added to the vaccine injury table. So in preparation for today's meeting, I submitted a letter to the ACCV dated November 24, 2020, outlining a condensed timeline of HRSA's public efforts to add and remove CERVA and syncope to and from the vaccine injury table. Briefly, HRSA presented on CERVA and specifically the Atanasoff paper to the ACCV in September 2010. Over a year later, by December 2011, proposed language to add CERVA and syncope to the vaccine injury table was introduced to the ACCV members. Changes and revisions in the language were presented upon and discussed by the ACCV over the next several years. However, in July 2015, the Secretary filed its Notice of Proposed Rulemaking to add CERVA and syncope to the vaccine injury table in the Federal Register, approximately 3.5 years after the language was first introduced to the ACCV. As you heard earlier, the final rule was filed in January 2017 and went into effect later that year. However, in contrast, the Secretary's efforts to remove CERVA and syncope from the vaccine injury table were publicly discussed in March of this year, and the Notice of Proposed Rulemaking to do the same was filed just 4 months later in July of this year. Now, all of this is occurring during a global pandemic while the race to produce an effective and safe COVID vaccine is underway. As discussed during the ACCV May meeting, as well as earlier this morning, the medical, legal, and policy considerations underpinning the Secretary's Notice of Proposed Rulemaking remain flawed. There is some discussion this morning regarding the vaccine fund and its growing balance, and I understand from today's agenda that there may be some discussion surrounding the medical and scientific aspects of CERVA later this afternoon. It is also really important to note that in the time frame between the Secretary's proposal to add these injuries and then remove these same injuries from the vaccine injury table, there has been no change in law. The Vaccine Act has not been amended in that time period. Presumably, legal counsel at HHS and potentially Department of Justice reviewed and approved the rulemaking to add CERVA and syncope to the vaccine injury table. Now, facing no change in the legal structure of the program, these same entities seek to reverse that course. Specific to CERVA, there has not been substantive changes in the medical literature describing CERVA and its related diagnoses. The literature repeatedly refers to immune-mediated inflammatory responses to an injected vaccine, often invoking antibody reaction to the antigen or other components of a vaccine. As we heard in Ms. Wringham's comments, the Notice of Proposed Rulemaking is not comprehensive in its discussion of the medical literature, but is very limited in its scope. The substance of the Notice of Proposed Rulemaking remains flawed, and the timing of the Notice of Proposed Rulemaking will work to damage public confidence in the national vaccine policy. I am happy to take any questions that may be answered from a legal perspective as somebody who represents vaccine-injured petitioners. And I'd like to thank the members of the ACCV for the opportunity to discuss the notice of proposed rulemaking today.
Christina, thank you for your presentation today. Does anybody have any questions for Christina?
Nope. No, thank you, Christina.
Thank you.
I have a quick question for you, Christina. You work with a lot of people who suffer vaccine injuries. What kind of a sense do you get when you tell these people that they may have to go sue their medical providers?
The people that we represent right now, those that are suffering SERVA, feel, somewhat hopeless in that regard and are glad that they still currently have the opportunity to move forward with the vaccine injury program. A big component of that is access to legal counsel without high fees incurred, having somebody experienced to guide them through the program, and certainly if the notice of proposed rulemaking takes effect and a final rule is implemented to change the program, certainly these claims may still be brought in the National Vaccine Injury Compensation Program. Prior to SERVA and GPS being added to the table, I would say that in my own experience, speaking solely from my own experience, about 90% of the claims that my firm files in the program were off-table claims, meaning that petitioner is required to prove vaccine causation to preponderant standards and bringing forward their claims. That often entails a lot more resources, financial resources, medical expert resources, and things of that nature. So while these claims may persist, if there is a rule change, they will undoubtedly become more complicated in process, more costly, and will certainly lengthen the time to get to a conclusion, and in theory, most likely overburden the court even more.
That's a great point. This is Karen. So I have a question. So what I just heard you say is that if you have a shoulder injury, you can still go to the compensation program, but obviously it's going to cost more in the long run. And so then it would have to be, you would have that argument if it was a vaccine injury before you go into the compensation phase. Is that correct?
I'm sorry, Karen, can you repeat the question?
So I was just making sure that even though it's going to be off the table, then you can still sue the vaccine injury compensation program. It will just be more cost effective. It will be more costly. And so going into that is more difficult and timely, but the program can still compensate if it is proven that is from the vaccine. Is that correct? So I'm just making sure that they can still go after the program and they don't have to directly go to the drug manufacturers.
So currently, if a injury is removed from the vaccine injury table, yes, a injured petitioner may still petition the government through the NVICP for compensation for the injury. So it's technically not a lawsuit, but their petition can still move forward. It will be off table, so again, petitioner is required to prove her case by his case by preponderant evidence. What that might require in any given case could vary, and it may have more to do with what a special master might be looking for in any particular case. But there's a fair amount, a high amount of cases that are off table that do require medical expert involvement. That also will increase the cost associated with processing the claim and more often than not lengthen the process. So yes, these claims will still be able to be brought as off-table claims in the vaccine injury program, but just overall will become more complicated. I think in the notice of proposed rulemaking there is a stated intent that the proposed rulemaking does not only seek to remove SERVA and syncope from the table, but there is a stated intent to remove them from the program overall. So I'm not sure what steps might be taken by the Secretary following the rulemaking, but I guess that's yet to be seen.
Thank you. That's super helpful. And, you know, it seems like it's going to be more costly overall because obviously the shoulder injuries aren't going away like we saw earlier. Thank you for the information.
Thank you.
Does anybody else have any questions for Christina? Well, I guess we will wrap it up. Thank you, Christina, for your time. We truly appreciate it. And thank you for the information that you provided to us. We appreciate that as well. And I guess if everybody's ready, we can take a break and reconvene at 12:30 Eastern time. Does that sound right?
This is Tamara. That's fine with me, John. Okay.
Okay. Well, then let's do it.
Yep.
All right. We'll talk to you guys here in a little while. Thank you.
Okay.
Welcome to the 115th Quarterly Meeting of the Advisory Commission of Childhood Vaccines. This call is being recorded. If you have any objections, you may disconnect at this time. I will now turn the meeting over to ACCV Chair, Mr. John Howie. Thank you, and you may continue whenever you're ready.
Thank you so much. Okay, so next we have Mike Milmo, who's going to speak with us, and Mike is an attorney who has a unique perspective because he worked for the DOJ defending vaccine injury claims, and now he works with vaccine injured people. So, Mike, if you're on the phone and ready to go, we appreciate you being here. Thank you.
So, operator, can you make sure that Mike Memo has an open line?
Yes, Mr. Mike, at this time, if you would please press *0 so we can open up your line. Again, that is *0. Mr. Mike, your line is now open.
Okay, great. Thank you so much. Thank you, John, for that introduction. I'm really pleased to have the opportunity to address the commission today. Can everybody hear me?
Yes, I think we can.
Okay,
Yes,
okay, great. I'm really pleased to have the opportunity to accept your invitation today to speak. I'm hoping that we'll have a good discussion after my presentation, that there'll be some good questions and we can kind of engage in an open dialogue about this matter. I'll just start with some biographical information. John's already given you a little bit of my background. My name is Michael Milmo, and I spent 30 years working in the vaccine program as a lawyer at the Department of Justice. In this role, as John said, I represented HHS in their vaccine claims. I retired in 2017, and I joined a law firm that now brings cases on behalf of petitioners. I was actually the very first lawyer hired to represent HHS in vaccine proceedings, and I tried very hard, and I tried the very first vaccine case ever all the way back in 1989. I was there in the 1980s when the Vaccine Act was created, and I've been practicing in the vaccine program ever since. My entire government career was devoted to making sure the Vaccine Act worked the way Congress intended. Having devoted my entire professional career to representing HHS on vaccine matters, care deeply about and I'm highly vested in the success of the vaccine program. With that perspective, I can tell you that in my opinion, this proposal is illegal, contrary to science, and will be a disaster for our national health policy. I'd just like to start with a discussion of the purpose of the ACCV, the very reason for your existence. Your own charter, which appears on your website, tells you that the main function of the commission is to provide advice and recommendations to the Secretary of Health and Human Services on the VICP. The charter says that you are 1, to advise the Secretary on the implementation of the program, and 2, to recommend changes in the vaccine injury table. The Vaccine Act itself, passed all the way back in 1986 by Congress, mandates that anytime the Secretary wants to change the table, the Secretary must seek your recommendation on those changes. In the entire 34-year history of the program, the Secretary has never moved forward with changes to the table without first obtaining the approval the buy-in, if you will, of this commission. That is until now. That is what makes what HHS is doing now so shocking. Secretary's action in putting forth the rule that was rejected by the commissioners, who were hand-selected by the Secretary himself to specifically advise him on rule changes, is unprecedented. It's just never happened before, and it leaves us in completely uncharted water. I do not need to remind you that in May of this year, the Commission considered the proposed rule the Secretary continues to put forth. The Commission voted unanimously to reject the Secretary's proposal after hearing from lawyers, physicians, scientists, pharmacists, drug manufacturers, and perhaps most importantly, from victims of SERVA. And you heard all the reasons the Secretary's rule should be rejected. And after thoroughly debating the issue amongst yourselves, the Commission wrote a strongly worded recommendation to the Secretary, providing over a dozen reasons that the proposed rule should not be put forward. You commissioners wrote eloquently about the legal, medical, and policy reasons this rule should be rejected. And yet the Secretary thumbed his nose at your recommendations and moved ahead with the rule anyway. Again, this is unprecedented. Let's not forget the makeup of the ACCV. The Commission is made up of many stakeholders in national vaccine policy. The 9-member commission is to be made up of 3 physicians, 3 attorneys, and 3 members of the general public, all who have differing perspectives on any number of issues, but who are all vested in making the VICP work in the interest of public health. In May, the 4 voting members who unanimously told the Secretary in the strongest of terms that his proposal should be shelved included 2 very respected infectious disease physicians with a lot of vaccine experience, a lawyer who specializes in vaccine law, the parent of a child who died after receiving a vaccine and who has been through the VICP and recovered an award. This is how Congress intended the Commission to work. Members of the scientific and medical community working with members of the legal community and representatives of the general public who want vaccines to be as safe as possible, all reviewing the available evidence. And here, coming to a unanimous conclusion that the rule being proposed violates medical principles, statutory law, and good, sound public policy. All the while, the Secretary refuses to provide any information to the Commission other than the rule itself. He refuses to have any of his doctors review the science with the Commission. He refuses to have his lawyers brief you on their legal concerns. He refuses to engage in any public debate. And he repeatedly refuses to make any health officials available for the media. What does that tell you? It tells you that the Secretary is doing something secretive, non-transparent, devious, and probably not in the public interest. And yet they wonder why they soon will have only 3 commission members after Commissioner Howey rolls off the commission in a few weeks. Why are they having such a tough time recruiting doctors, lawyers, and members of the general public to the commission? I think I can answer that question. Why would anyone join a commission when the Secretary simply ignores your recommendations? Bad enough when you've made recommendations to the Secretary about staffing levels, budget, the number of special masters, the use of exit questionnaires, inflation, all the things that the Commission has recently recommended to the Secretary. And all these things, the Secretary has done absolutely nothing. It's on his hands. But to me, it's even more egregious when the Secretary comes to the Commission with a proposal of his own that fundamentally changes the very character of the vaccine program. And he solicits recommendations as he is legally obligated to do. And when the Commission unanimously tells the Secretary this is a terrible idea that needs to be thoroughly rejected, he moves forward with it anyway, because he doesn't care what you think. They wonder why they cannot fill more than 3 spaces on the 9-member commission. Frankly, it's a wonder to me that the very 3 remaining members don't resign in protest, leaving no commissioners at all. Why is HHS so afraid of engaging on the issue with other vaccine policymakers, with the media, and with the public, and with the doctors and lawyers who specialize in shoulder injuries? Why the blackout for the commission? Why the total lack of transparency? We just heard from a very well-respected vaccine lawyer, Campolillo, and 2 doctors will soon speak. Dr. Bodor, who wrote the first published medical article on shoulder pain following vaccination, and Dr. Srikumaran, who is known, a renowned orthopedic surgeon from Johns Hopkins, who wrote a lengthy open letter to the Secretary on the science of SERVA earlier this year. Wouldn't you think HHS would want to engage in a dialogue with these kinds of professionals before they took a legal right-of-way that the Secretary himself instituted 3 years ago? Of course you would. The fact that the Secretary will not speak to these professionals or anyone else and will not speak publicly in any form to explain the reasoning behind the proposal tells you that, unfortunately, there's a good share of sleaze at play here. That's unconscionable when it comes to matters of public health. Secretary and the Department of Justice all but acknowledge that the real reason the Secretary is moving forward is due to the increased caseload, which is stretching thin the staff at both HHS and DOJ. They are not set up to handle so many claims, but the rule they are proposing is only going to make things worse. As Christina said, now the survey cases are treated as table claims, which very much helps in the speed of processing those claims. No experts are needed, and HHS ends up conceding, as Tamara's statistics earlier today said, about 40% of the cases. And then we move on to a discussion of damages. But the rule proposed by the Secretary means that there will be no more benefit of the vaccine injury table. That does not mean cases cannot be filed in the VICP. It just means that petitioners will have to get an expert in every case. Every petitioner who brings a survey case or a syncope case is now going to be the subject of a trial. The attorney time spent on each case will grow exponentially. Tamara gave you the numbers of attorney's fees in the last fiscal year being $6 million. Expect that to double or triple. Instead of processing these cases quickly, each survey petitioner will wait years and years for resolution of the case. In other words, the already stretched resources at HHS and DOJ will be stretched even more. This is perhaps the number one reason that the Secretary's proposal makes no sense whatsoever. I might add that if the rule does pass in early 2021, it will almost certainly be challenged in federal courts. In other words, the Secretary's signature on this rule in January 2021 will not be the end of this issue. The entire program would literally be held hostage in federal litigation for many years to come, with the lives of real people with real vaccine injuries being held in limbo. I'd just like to make a quick comment on syncope. A lot of people at the last couple of commission meetings have focused on SERVA, and appropriately so. But another aspect of the Secretary's rule proposal is to eliminate syncope from the table. HHS has been paying syncope cases for 3 decades now, way before the Secretary added it to the vaccine injury table in 2017. Science also supports the causal connection between vaccines and syncope. A review of the IOM, which Ms. Wrangham talked about, that led to SERVA and syncope being added to the vaccine injury table shows that the IOM reviewed many medical articles in their discussion of syncope, frankly, many more syncope reports than SERVA reports, and concluded that the evidence convincingly, that's their word, supports a causal relationship between vaccines and syncope. This Secretary should not be permitted to ignore science and reverse 3 decades of VIC policy. On a final note, as much as I believe SERVA and syncope should stay on the vaccine injury table, perhaps the most ominous and nefarious part of the NPRM may be the section which reverses the policy that the CDC and others in the scientific community decide which vaccine should be added to the vaccine program. The current regulation says that all vaccines recommended by scientists at the CDC, based on recommendations from the American Academy of Pediatrics, will automatically be added to the program if scientists recommend that a vaccine be routinely used in children. The Secretary wants to change that so that he and only he decides what vaccines are covered. This is another political ploy to make sure that even if the scientific community comes to the belief that children should routinely receive the COVID-19 vaccine, if the workload looks too great, the Secretary himself can decide whether to add COVID-19 to the program. He can push those injured by vaccines into a program far less friendly to those who are injured by the COVID-19 vaccine. They called this the countermeasures program, which leaves the rules for compensation up to strictly one person, who, surprise, the Secretary himself. The countermeasures program, no matter how much the Secretary may tout it, is a far inferior program to the VICP. Does not allow any award for pain and suffering. Your case is decided by the Secretary, not an independent judge. There are no judicial rights accorded, and you have to pay for your own attorney's fees. It's a dangerous precedent indeed that allows political figures like the Secretary to make medical decisions as opposed to doctors and scientists. If at the end of the day the scientists recommend that COVID-19 vaccines be recommended for the routine use in children, all COVID-19 cases should be covered by the VICP. There's no legitimate recourse for those injured by, if there is no legitimate recourse for those injured by the COVID vaccines, just like if there is no real recourse for those who suffer from CERVA or syncope, the American public will be disincentivized to get vaccines. This is exactly the wrong message to send America during a national pandemic when infection rates are skyrocketing again. The Secretary signs this rule into effect in January 2021, height of the winter and the high point for COVID and flu injections. This timing will clearly send the message that politics is more important than public health. Many people will simply skip the COVID vaccine. Thank you very much.
Mr. Milmo, thank you for your presentation. Does anybody have any questions for Mr. Milmo?
I guess I hate to be redundant. This is Karen. I'm still confused about whether the HHS will totally take this off the program at all, and then they will need to sue the provider, or will they still allow to be not a table injury, but you can go after the vaccine injury compensation program? And is that decision finalized, or is that yet to be known?
I think that's a fantastic question, and I think the answer is that's not entirely clear. You know, the way that the NPRM is written, it sounds as if HHS intends to take out syncope and CERVA from the program altogether. But in my opinion, as a lawyer who's been working on these cases for almost 35 years now, I don't think that's a proper interpretation. I think the more likely interpretation is the interpretation that Christina talked about, which is that we will now convert these cases into cause and fact cases, where every petitioner will go to trial, where every case will involve a medical expert, that will just drive the costs up in this program unnecessarily, and will drive the processing times from 2 or 3 years to 5, 6, 7 years. Again, these are real people. As a government lawyer, I unfortunately got into the habit, as I think the government does sometimes, is seeing these cases as statistics. But it's been a real blessing to my life to spend the last 3 years actually representing individual people and hearing their stories and realizing what a dramatic injury CERVA is. It's easy because of I think Tamara said there are 50% of all the cases are now CERVA cases. It's easy to lose perspective and realize that these are not statistics. These are real live people, and CERVA has devastated their lives. And I think that's just something very important and something that the Secretary is really not considering when he's putting forth this proposed rule.
I'm really grateful for your time. I feel, obviously, I'm not a doctor. I'm a parent of a child who died from vaccine injury. It seems this entire process has been extremely frustrating. I find it frustrating also that the board is at 4 people having this conversation instead of 9. But I also have a huge concern about Secretary being able to put vaccines on and off. I find all of it concerning, and I think that this is the first time that anyone's ever really talked about that issue, which I believe is a huge issue. So I'm so grateful for you bringing that up.
Oh, my pleasure. My pleasure.
Anybody else have any questions for Mike? Barbara?
I have a comment, not a question. Actually,
Fire away.
One potential question. So I agree with you. I was wondering also today as I was logging in why I'm logging in if nothing that we say really matters. So when you said that, I was like, amen to that. I feel like we are all getting together, spending enormous numbers of hours on the phone, and I feel like I'm just spinning like a the endless circle on a computer when it's stuck. So I don't know if I'm the only one in this committee feeling that way, and also the frustration of it being only the three of us. And what's the point? I really do wonder that. And if there's no point to this, why are we doing this? Because the first concern I brought to the committee when I joined was, if there's all that money sitting there, why can't we hire more people to process all these claims so that people can get there faster and there's not years and years of waiting? And I still feel like us saying that gets nowhere. And like you said, if this letter was sent and nobody's paying attention, again, what is the role of our committee? But that's my comment. My question is, and correct me if I'm wrong, since apparently you have a lot of experience on this, even if the ACIP recommends COVID vaccines, because they are under emergency use authorization, don't they fall under a different plan? You know what I mean? Like emergency use authorization vaccines, I don't think are protected under this. It falls elsewhere, but correct me if I'm wrong.
I think that's an excellent question and something that is by no means decided at this point. Yes, I think the original plan for people who are injured by COVID vaccine is that they'll be ushered into the countermeasures program that I discussed in my presentation.
Yeah.
However, that's just a factor of that because the children's studies have not really been conducted, as far as I know. Of course, you'll know a lot more than I will on that, but I mean, the vaccines that have been approved, as I understand it, just from the public media, those tests have been done almost exclusively on adults. So once that testing occurs with children, if the folks who put together the Red Book, working in conjunction with the CDC, were to decide that COVID vaccine is is appropriate for routine use in children, then there's no reason that those cases couldn't come to the VICP. It would only require that the secretary publish the notice into the Federal Register and to start to collect the excise tax. And the really scary part, I think, of Section 17 of this NPRM is that it gives that discretion solely to the secretary, whereas now the vaccines that are routine, recommended for the routine use in children are automatically become part of the VICP.
So I think I can help with that piece, because I do have a concern about that. And just to clarify for Karen and for the lawyers in the group, as you know, I don't speak lawyer, but I do speak clinical trials. I don't think, but I may be wrong, that emergency use authorizations fall under this, because by definition, emergency use authorization vaccines have not been thoroughly studied. They're still under review. So for a vaccine to get approval by FDA and to be recommended routinely, it needs to have completed all phases of a clinical trial. And the very name emergency use shows you that, like, for example, in the meningococcal B outbreaks in colleges, the vaccine was already being studied, but the studies were not finished. There were outbreaks in the country, and we knew we needed to make vaccine available to protect these teenagers, but the vaccine was not done cooking, if you want to call it that way. All the safety data was not done. But we felt like there was enough data to release it under emergency use, which means, you know what, this is an emergency, here you go, but we're not done with it yet. It's kind of like if you're launching somebody a log instead of an inflatable device to save them what's proven to save your life, but it's the best you can do at the moment. So I don't know that if a vaccine has not finished the process of being studied and all data is collected, it should be covered here, or could be, because it is not a vaccine that you can routinely recommend. Like vitamin V, it's only recommended if somebody wants it because we're in an emergency, but it cannot be enforced. In my hospital, for example, as soon as the vaccine is available, it's not mandatory for employment like influenza. It's just available for staff members.
So this is Tamara. This is Tamara, and as Mike has stated, currently if a COVID vaccine ultimately becomes used, it's covered under the Countermeasures Injury Compensation Program. And for it to be covered under the Vaccine Injury Compensation Program, it would need to be recommended for routine administration to children and or pregnant women.
Yeah.
by the CDC. So that's the first step that needs to occur. Then Congress is the one that imposes the excise tax, not the Secretary. Congress has to impose an excise tax on the vaccine because that's the next step that would need to occur. Then the step after that would be that it would need to be added to the vaccine injury table.
Yep.
So those are the steps that need to occur before it could be covered under the vaccine injury compensation program.
Yeah, that makes sense. Thank you. That clarifies it.
And then I do want to say, okay.
I was just going to say, I do think both of you have clarified that yeah, more studies need to be done before, you know, the CDC would recommend it for routine use in children, and then the process would unfold the way that Tamara just described.
Yes.
Bill Spiegel here. I have a question for Mike. Mike, can you hear me?
Yes, I can, Bill. Thank you so much.
Okay, great. Thank you. Very informative. And listen, I'm the newest lawyer member of the committee. I don't litigate directly in vaccine injuries, but in medicine and medical malpractice. But I just had a question, and you can tell me if I'm getting too far beyond the immediate concerns. But if the Secretary goes ahead and proceeds with the rule change, and I believe it's January, and you mentioned this will lead to a great deal of litigation, I'm curious, who will bring that litigation, and what will happen to the compensation injury setup as it stands? Will everything just be on hold during that time?
I think that's very much a possibility and a great question. I do believe there'll be federal litigation. I think it'll be brought by people who would otherwise, be able to avail themselves of the vaccine injury table protections, who the day after the Secretary signs the proposed rule are no longer eligible for those protections. So I think the case would be brought by, lawyers representing people who, had a very good and viable table claim on Tuesday, and on Wednesday are shut out of that and forced to prove causation and fact.
Okay, great. Very helpful. Thank you.
Sure.
Mike, this is John Howie. It's interesting to me that you sit and we talk about the fact that, removing these claims from the table is only going to increase the cost of having to process and handle these claims from start to finish, not only on the government side, but also on the vaccine injured petitioners bar's side. Is that right?
Absolutely, John. When these cases are moved to causation and fact, each case will then have to have an expert, someone like a Dr. Bodor or Dr. Srikumaran. That's very expensive. And all of these cases will then have to be decided by special master. I think Christina alluded to the fact that hopefully not all special masters, once they get all of those reports in, will take each and every case to trial, but that's a very real possibility. Having practiced in this program for 35 years, most of the cases that are done off table go to trial. I mean, 99.9% of them do. And so you can imagine the additional litigation costs that are going to be expended by lawyers and their experts over 2 or 3 additional years of litigation, and we'll be, we're submitting that for payment to the program, and that will raise the cost of doing business. I noticed from the statistics that Tamara kindly put up later that it looks to me that the processing costs by the attorneys is approximately 10% of the amount of words that are given out. I think that's a pretty low number and a number Congress would approve of. 10% of administrative costs, relative to a big program that pays out, that's already paid out $4 billion. That's pretty reasonable, in my opinion, and I think in Congress's opinion. But that number is going to rise. It's going to rise dramatically. Like I said, two or three times over for every hour that the attorney is required to participate in, court litigation. Everybody knows how expensive and drawn out that is.
May I ask one more question that may or may not be related? Pardon my lack of information in politics. With Biden taking over, he will have to choose a new HHS secretary, correct? So will this change all this stuff we're talking about? Could that potentially be completely reverted when the new secretary comes on, or how does this work?
That's another brilliant question, and I think the answer is very possibly, as Christina went through so eloquently in her presentation. After considering adding these table injuries to the table for a period of over 5 years, 5 to 8 years, or 5 to 7 years, it was the very last day of the Obama administration where the secretary, the Democratic secretary, signed the final rule that, allowed these things to become table injuries. It may not say nothing about politics. I don't want to enter that arena at all, but is it possible that the current secretary with the current administration could sign the thing on the very last day of the Trump administration 4 years later and reverse the whole thing? I think that's very possible. If that doesn't get done during that very narrow window between the 13th and the 20th of January when President Biden is sworn in, I think that may change the whole discussion. He may revert back to what his President Obama advocated for back in 2017 on his very last day in office.
Complicated. Thank you.
Mike, this is John Howey. My phone apparently got COVID and cut off right in the middle of your answer, but I think you answered the question that I had, which was who's going to bear the cost of all of this additional litigation?
The program will, John. The Vaccine Act sets up a very unique, situation for the payment of attorney's fees, and Congress did that knowing that the fees could be, quite expensive in some cases, but they wanted to make sure that people who were injured by vaccines had adequate legal representation. And so, unlike so many areas of the law, the attorney's fees are paid for by the program itself. They are approved by the court. But once an attorney makes an application, the court reviews it, determines whether it's reasonable or not, and then the judgment, if you will, that payment is made from the trust fund. And so you're exactly right. It will cost the trust fund infinite amount of dollars to process these cases as causation of fact cases.
So not to belabor the obvious, but why wouldn't HHS just take some of that money that they're going to have to pay to all the lawyers that represent hurt people and hire more reviewers?
That's not a question for me, but that makes good sense. I've having worked in the government for as long as I do, I have tremendous respect for everybody that works at HHS. If I implied anything differently in my presentation, that's not purposeful. The people who work in the vaccine program, the actual workers like Tamara and her staff, medical doctors, they work incredibly hard. They're fantastic people. I know a lot of them have tremendous respect for them, but I've never been able to figure out exactly why new ideas aren't coming forward, and like in private industry, when the economy goes bad and your product isn't selling quite as well, they have to make adjustments. They can't do things the same way that they've always done them. And having worked for the government, I can tell you that's a real bugaboo, because the government has established processes that go back decades, and they're very reluctant And I don't say that as a criticism of HHS. That's true at DOJ. That's true. My father worked for the government. I mean, I've seen that all my life. The government is very hard to change. And as you can imagine, a big, huge bureaucracy. But I do think new ideas have to come up for how to process these cases more fairly and more quickly.
So this is Tamara. So I just wanted to remind you all of how the budgeting process works, is that Congress is the one who ultimately appropriates money. So if we're to get an increase, it would be Congress that makes that determination. So, you know, HHS and the president can be supportive of it, but ultimately Congress decides. It's not HHS that decides. It's not the president that decides. It's Congress decides to appropriate additional funding for the program. And the ACCV cannot lobby Congress. So the ACCV can only make a recommendation to the secretary, which you all have done, and you know, the program appreciates it, but it's not ultimately up to the secretary to decide. It's up to Congress to decide. So just to make that clear to people.
I think that's an excellent point, and I agree with it completely. I guess my only point in making the comparison that in private industry, when there is COVID or there is some reason for your product not to sell, your services not to be needed as much, they take the money that they already have, allocate it differently, and they make changes in the processes to make sure that they don't go out of business. And I think the analogy is, you know, respectfully, I would submit that the analogy is just as apt here. You know, I realize you only have a set amount of budget, but what we do with that budget, we have to find other ways of making sure that the program still works.
Does anybody else have any questions for Mr. Milmo?
This is Karen. I just want to make a comment again. Thank you so much. You know, it's very frustrating that HHS isn't responding to these concerns. You know, the simple, it feels like this is what this board was created for. I mean, we're here because of the 1986 Act, and so by law, there should be 9 members of this board. We should be meeting, you know, we should be meeting twice in person. We should be building this relationship, and it's very frustrating because it seems like many of us have the same tone on the NPRM, but we're not, you know, it just feels like we're just, you know, beating the dead horse having this conversation, but it's very, very important. And you know, at the end of the day, I believe as a parent who's lost a child that the trust is real. The trust is a huge issue, and by taking this off the table, it's very concerning to a lot of people, and it's not like the shoulder injury is going to go away. We can see clearly that, you know, it's an enormous amount of people who are having shoulder injuries. So I just wanted to say that for the record. Again, thanks again, Michael.
Sure. John, could I answer one question that you asked Christina that I've answered just a tad differently than she did?
Yeah, absolutely. Please do.
You asked her, you know, what is when people contact her office, do they, you know, reference the idea of having to sue their doctor? And you know, our law firm handles a lot of SERVA cases. We probably get, I'm guessing, maybe around 20 inquiries or more each week that I field or other attorneys in my office field, and that is an issue that comes up all the time. The first question many potential petitioners ask me is, my gosh, am I going to have to sue my doctor? And I can reassure them, saying, no, your doctor will not be sued. This process is not, you know, very unlike a Social Security claims process. You're claiming benefits from a public fund that's been created specifically to pay for vaccine injuries, and that's a great thing. You know, petitioners don't want to sue their doctors. They have a tremendous amount of trust in their doctors. They tell doctors, you know, things that they don't even tell, you know, their own family. It's a confidential relationship. It's why the law recognizes such a sacred relationship between patient and physician, the same way they do, priest and penitent. It's a sacred relationship, and the idea that HHS, this proposal would have petitioners sue their own doctors, I mean, that will knock out 90% of the claims right there. They'll just won't do it. I mean, when I get these calls, they tell me if I don't even want Dr. Snuffy to know about it. I love Dr. Snuffy. I've seen him for 20 years. I don't want to sue him. I don't even want him to know about it. I can always assure them they won't know about it. I will request your medical records, and that will likely be the end of their participation in the case. The people that call us and the people that we represent, we've got like maybe 400 SERVA clients. They tell me if I have to sue my doctor, I'm not getting any more vaccines. I'm never getting another vaccine in my life. And that's just the exact wrong message for us to be sending to America right now. That we're going to violate that trust between you and your doctor. We're going to get in between that relationship. That's just wrong.
Yeah, and I'll tell you, I share the same feeling in the sense that I have the same conversation with my clients over and over and over again. Because, you're exactly right. People tell their doctors things that they don't tell their spouses. They don't tell their kids. And it's a very strong and very personal relationship. And I know Bill, being new to this board, but Bill brings a unique experience because he talks to the doctors that are getting sued when they get sued. And I'm sure they feel the same way. Anyway, I appreciate your time, Michael. Thank you.
Yes, thank you so much, John. Appreciate the opportunity.
Of course.
Thank you.
Annie, do we have somebody lined up next?
Yes, I believe we have Dr. Bodor on the line. Operator, can you open his line?
Doctor, if you're on the line, please press *0.
Hello.
Your line is open.
Can you all... Hi, I hope you can all hear me well.
Dr. Bodor, good afternoon. How are you today, sir?
Yes, I'm fine, thank you. I will speak for 15 minutes. First of all, I'd like to review a little bit of the anatomy of the shoulder. So you have a ball and socket joint. You have the humerus, which is your arm bone, that is the top of which has a ball. And
one quick question, sorry. Are we supposed to be in slides or just listening to you, just to be sure I'm looking at the correct thing?
I don't know. You can decide whether you want to listen or not. I don't care.
No, I mean, of course I'm listening. I'm wondering if I'm supposed to be looking at slides as well because I only see the agenda.
I don't have any slides.
No problem. Thank you.
So, the shoulder is a ball and socket joint, and it has the arm bone, it's the humerus, and then there's a scapula, which is your shoulder blade. And there are two big muscles that control two sets of muscles that control the movement of the arm when you raise your arm overhead. The outer one is the deltoid. It's the big muscle you see that if you have a big weightlifter, you could see a big bulging muscle that makes their shoulders really broad. And underneath that deltoid muscle, there's something called the rotator cuff. And that's a group of 4 muscles that kind of help to position that ball in the socket, whereas the deltoid is the big mover. Like the deltoid is a big power thing, and the rotator cuff, they're like the positioners. And between those two sets of muscles, there's something called the shoulder bursa. And the bursa is a little fluid-filled sac that provides lubrication between those two muscle groups. So a typical vaccination is delivered to the deltoid muscle, and it should be delivered to the middle of the muscle, which is where the muscle is the thickest. But sometimes it goes higher up, and we think that is if the patient exposes the top of their shoulder, like if they go to a pharmacy and they don't pull their shirt up, they pull their sleeve down, that exposes the upper part of the deltoid. Or if they maybe go through a drive-in where the person providing the vaccination is standing and they're sitting in a car or something like that. Then the person may mismeasure, and then instead of going in the middle of the deltoid, they go to the upper part of the deltoid, and the upper part of the deltoid is thinner, and the upper part of the deltoid, it's only like a quarter-inch to maybe at most a half-inch thick, and the typical needle is 1 inch thick, long. And so if you put a 1 inch needle and you mismeasure and you don't go a quarter-inch, and you don't go 3/8 of an inch or a half-inch, but you go too deep and it's the upper part of the shoulder, then you're going to hit either the bursa or the rotator cuff underneath or the bone underneath that. So when I originally published this paper in 2007 describing the first 2 cases, I just talked about a bursitis. And I was just saying that it's probably something like inflammation of the bursa. But since then, we've had MRIs and other findings and other papers that have shown that it can be the bursa, yes, but it oftentimes is the rotator cuff, and sometimes it's the bone. So it can be the bursa, the rotator cuff, or the bone, all the way down. And, you know, considering how many vaccinations are done in the United States, like 300 million flu vaccinations, 300 million total vaccinations a year, I mean, this probably happens, I would say, probably every 100 vaccinations goes into too high up. But, you know, we don't see 3 million server cases a year. It's probably because most people, it doesn't affect them. But just like vaccinations can affect some people in idiosyncratic ways, it can cause a persistent inflammatory reaction, you know, cause a systemic reaction. Same thing here. If the vaccine goes into these structures and it cannot get cleared by the bursa, it cannot get cleared by the rotator cuff tendons. Those are tendons, by the way, underneath that muscle. They're tendons, not the muscles. Or the bone, it doesn't get cleared. It can just get deposited there, and it doesn't get cleared. And if they happen to have a pre-existing genetic or environmental susceptibility, like they might have had vaccinations before, typically we see this in people who've already had vaccinations, so they've been sensitized to react, then they can develop this chronic inflammation, which leads to chronic pain. And oftentimes, yeah, after 3 months or 6 months, it gets better. But sometimes it just goes on and on and on and just stays there for years or forever. And so we have recently published a paper, actually it's in the process of being reviewed still, on the fact that we found that there are 2 specific tendons that are most often involved in these cases of chronic pain. That's the infraspinatus and the teres minor. And these tendons are positioned exactly under the outside of the shoulder, right where the needle would go. Up until now, people would just say, yeah, it's kind of like in the bursa or it's kind of in the shoulder, but no, we found exactly the location. And based on these coordinates that we found where this location is, we use ultrasound and we have found just little clues, little trace clues as to where the vaccine might be. And so we've provided anesthetic there, and by providing the anesthetic, if the patient's pain goes away completely, then we found the spot. And if we find the spot, then we use a system that was developed to remove cataracts, and it vibrates with ultrasound. It vibrates and it can suck out, it can dissociate the vaccine from the collagen, kind of like a washing type of a thing. And it can dissociate that and then suck out some of the vaccine. And it can, after a few days, we notice that the pain goes away and the function returns. And we've done 8 patients with this system, and they've all done very well. So we haven't done a double-blind randomized controlled trial because it's hard to get a large number of patients. And we have had really good results. So the disability index goes from 69 or 70 on a scale of 100 to 2 or 3 within a few days to a few weeks. So that's very exciting. And in my career, I have seen 20 patients with SERVA from 2008 to 2020 in my practice. So, you know, it took 12 years to get 20 patients. So as we know, it's not that common, but yet it is prevalent because of the number of vaccinations we have in the United States. So if we have 300 million vaccinations, and a recent study that came out by Hess, Elizabeth Hess, and colleagues from Department of Health and Human Services, actually from, they're also affiliated with the VICP program, but they looked at 3 million vaccinations in the Kaiser system, Kaiser and a number of other health systems, and they found that the rate of bursitis was about 1 out of 100,000, 125,000. Now they didn't look at tendinitis in the search terms, and I asked them why not, and they said, well, because the Institute of Medicine only recognizes bursitis as a proven injury from a vaccine, and that's based on my original paper. But since then, I found that it can be not just bursitis, but tendinitis and also a bone contusion. So if we were to include those diagnoses in the Kaiser system, we probably would find more cases. So I would say the rate is probably not 1 out of 100,000, but maybe 1 out of 50,000. So probably about 2,500 to 5,000 cases per year that are happening, that this injury happens in. So that's my presentation. I just want to say that, yeah, if you injected, we inject into those tendons all the time with salt water, with sometimes cortisone, with platelet-rich plasma, PRP, that's from your own body, your cells from your own body that can heal. And we poke around in that tendon all the time, and we don't see this type of a chronic inflammation. Now, granted, I haven't poked 100,000 people. I haven't poked 1,000 people or something like that. Well, I probably have poked about 5,000 to 7,000. I haven't had more than maybe 1 or 2 people have persistent pain after me poking. So I do think it's definitely different, and it's not just a coincidence that these injuries occur. That's oftentimes it's a criticism is like, well, it's a coincidence. They would have had that, you know, if you have enough patients and enough vaccinations, some people are going to develop tendinitis on the same day as their vaccine, just out of random chance. But the interesting thing about the cases that we've seen, we've done 8 of these patients, they've all involved the same 2 tendons, infraspinatus and supraspinatus, and infraspinatus and teres minor. And the most commonly involved tendons that happen with just degeneration are the rotator cuff tendon of the supraspinatus. So that was not involved. So, you know, what are the chances that it's going to involve the posterior rotator cuff as opposed to the anterior rotator cuff 8 cases in a row? Well, if you do the math on that, it'd be 50% times 50% times 50%, you know, 5 times. So if we talk about 5 cases, that's a 3% chance that this was by random chance. If we talk about 8 cases in a row, that's a really, really low chance that this was all, you know, random. So it looks like this is definitely not a random occurrence that especially when we find those 2 tendons to be involved. So I hope in the future that we'll be able to have a better way of recognizing this, and I think we are going to have a treatment. So far so good. We have had excellent results for this, and I think this is not going to be a chronic injury issue in the future. So I think we'll be able to cure it. That's my presentation. Do you have any questions?
I do.
Yes.
So a quick question for you. It makes sense to me that this injury is real. I do not doubt for 1 second that it's a coincidence. I do understand that if you inject something into a nerve, it could potentially be react. So, and it also makes sense to me as you described that steroids would not do that, and that plasma or our own system would cause inflammation. My question is, are you aware of any other injuries such as, I don't know, antibiotics or any other foreign substance that's not a vaccine, that's not plasma, that's not dexamethasone, that could cause a similar injury? Because to me it makes sense that the injury is caused by some foreign substance that is injected directly into the nerve.
Now you're talking about nerve, or you said nerve, but you mean this, in this case, we're not dealing with an injection into a nerve. We're dealing with injection into the bursa or the tendon or the bone, not the nerve.
Bursa, tendon, or any other of those structures involved.
Yeah, no, I'm not aware of anything else. I mean, I have heard of a case out of Seattle where somebody had a vitamin B12 injection, and that supposedly caused some issue, but it wasn't clear, and I told them that it did not look like it was clearly associated. So the answer is no. I'm not aware of anything else besides a vaccine that would do this, but anything that can cause an immune response potentially. I mean, if you injected some substance that can cause a persistent inflammatory immune response, that that's an antigen, and that's how vaccines work. It's an antigen. It's something that your immune system reacts to. So yeah, could there be another antigen other than a vaccine? Of course, but but it's an antigen. It's something that's going to cause a persistent inflammatory reaction. Potentially, if you injected bacteria or a virus into the tendon, it could do the same thing, because that's what the vaccine is supposed to imitate, a virus. It's supposed to imitate bacteria. So if you put the actual bacteria or the actual virus in there, yeah, that could cause a persistent inflammatory reaction too.
Yes, agree. And I think part of the issue is, as you very well have said, we are not injecting random things into people's arms routinely, other than maybe vitamin B12, like you said, vaccines or steroids. So this is the injury we're seeing because this is the one antigen that gets deposited there frequently, which is vaccines.
Yeah, I mean, there are some intramuscular injections that are done in the hospital and so on. Like, let's say somebody has nausea, you can inject Zofran. It's an antiemetic. And that people, nurses can provide that in the hospital for nausea. Yeah. And I haven't asked recently whether they, put it in the leg or they put it in the arm, but I haven't heard of any cases with, a drug like Zofran or something like that.
Yeah, and I think normally, I do work in a hospital. Normally those go IV, especially if the patient has an IV on. So I think, again, the proportion of patients that would get Zofran in their arm compared to the proportion of patients that get vaccines, again, if it was real, if it happened with Zofran, we still wouldn't see it because we don't inject Zofran on people's arms as often as we inject vaccines. So it makes sense to me that this would happen. And what I'm saying is I agree that it's related to the vaccine, and it might be related to other things. We just don't see those other injuries because they don't get injected there.
Yeah. Any other questions?
Dr. Bedore, I have two questions for you, and I'll ask both my questions, and I'll be quiet and let you answer them. Number one, do you have any thoughts as to why this is an injury that is so prevalent amongst adults but not children? And number two, this procedure, this treatment procedure that you've described, is that a procedure that you're performing on an ongoing basis, or is that something that you did and then you're waiting for your paper before you do any more? Thank you.
Yeah, good question. About children, I think that potentially, I haven't thought of this before, but now that you asked the question, I had a little bit of a light bulb went off in my head. I think that the rotator cuff of children is more vascular, it has more of a blood supply. And we know that a lot of things are very, very vascular, have a big blood supply in children. And then as we become adults, these structures, whether they are the discs in the spine or they become avascular. So probably the tendons are more vascular in children. And the other thing is that the technique must be a little different in children. They are probably exposing their shoulder completely. People don't hesitate to take kids' shirt off completely, and they're targeting a little differently. So I think that's a reason. But I think the blood supply issue is something that, and the other thing that's been brought up is that maybe the children haven't been exposed to as many vaccines. But I worked in a pediatrician's office, my dad's office, and yeah, we started getting vaccines when they were 6 months, 18 months, and all that stuff. But I think typically my dad was injecting in the thigh for those little babies, and the shoulder is probably less commonly used in children. So anyway, I'm not a pediatrician. I'd have to refer to them.
I am, and so I can tell you, I agree with you. Most of these vaccines in infants are given in the thigh. Back in the day, it used to be the gluteus, but now it's the thigh. And when we do give it in the arm, again, maybe I'm wrong, but pediatric vaccines are given so often that our nurses know very well how to give vaccines, and maybe adult nursing has less experience with it because they just don't do the volume of vaccines as we do in pediatrics. Maybe that might be another reason why the needle is going in a little too high or something. It's just a hypothesis. Right.
And also, a lot of these have been in pharmacies. A lot of 50% of these cases have been in pharmacies where they're not as experienced, and also you can't expose people. You can't expose the deltoid as well in a pharmacy unless you have a sleeveless shirt or that kind of a thing. And the second question was, am I doing this on an ongoing basis? Yes. our paper has 5 cases where we had 1-year follow-up on them. We wanted to make sure that's the surgical treatment outcome standard is 1 year. And this is really not a surgical thing. It's done through a 2-millimeter incision. And I put it in, it's just like a very large diameter needle that gets put in and it vibrates. So it's a 14-gauge needle. So it's really just like an injection, this vibrating thing. And it's done with ultrasound. The patient's awake. So it's not like it's much smaller than arthroscopic surgery, much less of a big deal. It's done just under local anesthesia or with a little bit of sedative, but under local anesthesia. And so, yeah, I've done 8 cases so far in the last year. And, yeah, people have come from Texas, from Atlanta and Boston. And so far, so good. I mean, the thing is going to be you're going to need somebody who has really good ultrasound skills to do this because everything is being viewed through a 0.5 millimeter window. You're looking at the shoulder. It's not in 3 dimensions, but you're just looking at a one slice at a time, a 0.5 millimeter slice at a time. And so you have to have somebody who can kind of take that 2-dimensional image and put it in their brain. And so that's going to be the challenge. And it's a challenge for us to publish this because, number one, some people didn't believe in this syndrome. And number 2 is now you have a treatment, but you only have 5 cases. So the treatment standard is you have to have 20 cases, 30 cases, and so on. So we were having a little bit of trouble convincing people. We submitted to one journal, and they were not convinced, and looked like there was some political bias in one of the reviewers. So anyway, that's the answer to the second question.
I appreciate that. I only ask that. I can tell you, as with Mr. Milmo, I field a lot of calls, and I have a lot of clients that are suffering and continue to suffer, and they say, what do you recommend? What can I do? And I tell them the treatment course is fairly standard, but Dr. Bodor out in LA may have a solution. So I'm going to keep telling them that, I guess.
Yeah, I mean, I had tried everything on these before. Cortisone, and the first 2 cases did respond to cortisone. They had mild inflammation, and fortunately they were able to clear the vaccine over time. And I hope that many people can clear it themselves. But in those who have persistent pain, that means the vaccine is not getting cleared, then this is the treatment. And I tried the PRP, I tried physical therapy, we tried even stem cell in one patient, like bone marrow stem cells, which have immune modulating properties. Didn't work. None of that stuff worked. And every time I did it, I would tell people, oh, this is this great new stuff, so it's going to, this is what it's going to do. So the same I had the same enthusiasm, but it didn't work. And then now with this really did work. So this is and this is working unbelievably well. I mean, I'm beyond my wildest dreams, because I thought I'd be happy if their disability went from 69 or 70 to maybe 20. But they went from 69 to 70 down to 2 within like 2 weeks. So it worked really well. And Dr. Srikumaran, who'll be talking later, he and I got to know each other through this program, and because of his letter and so on, I contacted him. So he actually is going to be a co-author on the paper.
That sounds wonderful. We're looking forward to it. As I said, I've told a lot of clients that your paper is out there and it should be coming out soon. So does anybody else have any questions?
If they have any issues, I have a YouTube video that describes everything I described. It's just 3 minutes. I have a model and everything. They could just YouTube Serva and Boder. So.
That sounds
This
great.
is Karen. Thank you so much. That was really great. I wanted to just say that before the NPRM came up, I never had any, I didn't have any idea how really devastating the shoulder injury could be, because it is debilitating. But also I wanted to make the comment that now, I think in April, HHS made it so the pharmaceuticals can give vaccines to children 3 and up, that we may unfortunately start to see children with these type of injuries. I mean, we don't know yet because this just changed, and I think honestly with COVID, people aren't going to their doctors. Right. So,
although Karen, I think that's limited to children over the age of 8, I think, and don't quote me
no,
on that.
3, the age of 3.
Right. Interesting. Okay.
But thank you so much. That was really informative, and it
okay.
gives me hope.
If there are no further questions, I'm going to say goodbye and have a great day.
All right, Dr. Bodor, thank you so much. We appreciate it.
Thank you. Bye-bye now.
Annie?
Yes, sir.
How are you?
I'm good. How are you?
I'm good. Are we ready for Dr. Shrikamaran?
Yes, he is on the line. So, operator, can you unmute his line for us?
If you would please press *0 at this time so I can unmute your line. Thank you.
And I'm going to ask the same question. Will there be slides we need to be looking at or just listening?
He did not provide any slides.
Thank you. That way I won't interrupt again. Thanks.
You're welcome.
Doctor, are you with us?
Okay, thank you for your patience. Your line is now open.
Doctor, good afternoon. Thank you for being here today. We're all looking forward to hearing what you have to tell us about, so I'm going to yield to you. Thank you.
Thank you. Good afternoon, everyone, and thank you for this opportunity to provide some additional comments regarding the final rule. I did read that proposed rule, and as you know, I submitted an open letter previously. So I did have some concerns, several concerns about what's been written since. And I'm sorry, I haven't been on the call the whole morning, but I have heard prior comments from Dr. Bodor and a little bit of the discussion prior to that. So I apologize if I'm repeating anything, or and please feel free to interrupt me and ask questions along the way. I don't think I have more than 5-7 minutes or so. The proposed rule notes that, and I'm quoting here, the scientific literature indicates that SERVA likely results from poor vaccination technique rather than the vaccine or its components alone, end quote. So this statement seems to acknowledge, compared to their first document, that both the injection and a vaccine antigen are required to elicit the SERVA syndrome. And this is what we've argued previously. But it seems, and this is concerning to me, that now their primary argument is that SERVA can only be caused by this inappropriate or negligent technique. And they use this term negligent throughout this document. So I think that is kind of fundamentally misleading with respect to how that scientific literature is being interpreted. And I think it does require a bit more nuance in interpretation. And I know it starts off with the Institute of Medicine report stating that these injections and not the contents of the vaccine really contributed to this deltoid bursitis. But I think it would have been more appropriately written as the contents of a particular vaccine in that Institute of Medicine report. And that really would acknowledge that vaccine antigen along with the injection into or even just near the bursa to cause this response. And as Dr. Bodor was the first to report this, and he's noted, it's based on those studies. And then the Atanasoff study afterwards, the larger series of this, notes the same, that, and I quote, the rapid onset of pain with limited range of motion following vaccination in our series of patients is consistent with a robust and prolonged immune response within already sensitized shoulder structures following injection of antigenic substance into the subacromial bursa or the area around the rotator cuff tendon. We believe that this type of phenomenon is not due to a specific vaccine, but results from injection of a vaccine antigen to which a person has previously been sensitized as a result of previous naturally occurring infection or past vaccination. End quote. So the proposed rule document kind of further notes that, quote, the medical literature supports the possibility that SERVA may result from inappropriate needle length and or injection technique. And then they quote, end quote, and then that sentence quotes this Atanasoff article. And then the document also goes on and says, quote, there's nearly uniform agreement in the scientific community that SERVA is caused by improper vaccine administration rather than by the vaccine itself. And end quote. And I think you've discussed that that's just not the case. And their citations for that statement were a 2-person case report from Australia, the Cross article, and a single patient case report, Barnes. And even the Barnes article notes that this was meant to just be a catalyst for discussion, and they weren't suggesting that you could eliminate this with completely appropriate technique. And I think a more appropriate interpretation of the literature would be that it suggests that proper technique can reduce the incidence of SIRVA, but unlikely can eliminate it completely, and that is what is repeatedly stated in the largest studies of SIRVA. For example, Atanasoff again suggests, quote, the act of inserting a needle or injecting non-antigenic substance into the deltoid muscle would not be expected to cause an immune-mediated inflammatory response. Careful consideration should be given to appropriate injection technique when administering intramuscular vaccinations to reduce the risk of shoulder injury. End quote. So I think you see over and over in the literature that it's really about risk reduction and not elimination. And in that article, too, only 46% of the patients kind of voiced concerns about how their vaccine was administered, noting either a high location or a deep injection. So it's not like every case that exists in the literature has this type of history, that they were all inappropriately placed. I would liken this to a commonly understood risk and complication of any surgery, which would be infection. So there are several measures healthcare providers can and do take to reduce that risk of infection, but we've yet to be able to eliminate this risk. There's patient-related factors, there's certainly provider-related factors, and despite our best efforts and understanding of this process over hundreds of years, we're not able to eliminate this risk. And patients, I think, can understand that surgery has this risk of infection, and we do the best we can to mitigate that risk, but it's not possible to get it to zero. And nor is every infection due to negligence of the surgeon. And I think Boder, which is great to hear, also noted that this was based, these recommendations are based about this original bursitis and avoiding the top third. He even, in his original paper, the quotation is reduce the risk of, and I don't think the majority of the literature says anything about eliminating server risk just from technique. And I think that makes sense from the discussions I've heard previously, that we're not even sure that the needle has to penetrate past the deepest aspect of the deltoid to cause a bursitis. It could be just deep within the deltoid and it potentially still cause this type of reaction. I think everyone can appreciate inflammation, which is what we're talking about, tends to spread to adjacent structures. If anyone's rolled their ankle and watched the swelling occur, it spreads incredibly from the original area. If you've had a bee sting somewhere, you can watch that swelling spread. So it's not clear fully that this service syndrome results from direct injection into the bursa. It can be adjacent, and it likely has varying response based on the dose and the position and the distance from these things. So even the Barnes article that the proposed rule quotes, that the current CDC guidelines for needle length suggest a 1-inch needle for the vast majority of adult patients. And this is in contrast to some studies that have been done. You can look at this Leipert article, that they recommended a weight-based, gender-specific approach. And so they conclude that this Barnes article concludes, quote, additionally, the vaccine over-penetration that likely led to SIRVA in their single case could have been prevented by refining the Centers for Disease Control and Prevention's current injection guidelines, end quote. So this would argue that the CDC guidelines are not adequate in their present form to prevent SIRVA, yet the proposed rule document suggests this negligence is on the part of common healthcare practitioners. So I would again say that it's far more accurate to suggest that increased training and education can certainly reduce the incidence of SIRVA. I just don't think it's plausible that those measures alone would prevent this condition entirely. And are we really suggesting providers are negligent if we're following current CDC guidelines? I think it would be more logical to add these best practice documentation to do vaccine administration records or medical records, and it's pretty easy to document needle size, entry point, and how someone is positioned if that's what's necessary, rather than trying to assign blame of sort of on sort of well-meaning and well-trained professionals. And I think some of the other concerns that are brought up are also relevant and suggested by the literature. Again, the Barnes article suggests that SERVA may be underreported in their the adverse event reporting system. It is passive, and there are medical legal concerns and risks involved with that, and that might even be evidence that most are really unaware of this vaccine injury compensation program. I know I was not aware of this until very recently. So by removing it from a no-fault system, you actually risk underreporting of a actually readily treatable adverse event in many cases, as you guys have just discussed, and Dr. Boder has presented a new technique caught early and with more awareness. I think you can treat it more easily with cortisone injections, and should you need, it can be treated with arthroscopic surgery. So I think this actually represents, a no-fault system represents a very sensible way to manage this unfortunate adverse event related to vaccination. I think those involved in setting this whole program up should be lauded, really, for the foresight and insight and ability to fairly balance the interests of the general population as well as the healthcare providers that provide the service. I think it's a great model, and making use of specialized personnel and subject matter experts to adjudicate cases, removing the stress and burden from healthcare workers, I think is a tremendous benefit. I mean, I can tell you, the surgeon, we definitely carry every single one of our complications with us, and whether it can be traced to our technical error or not, it's a significant stress that's carried around with us, and it's not really outweighed by the thousands of other patients who may have helped. It's just it's something that stays with you. So I think this model should really be held up as a great way to even consider for the private sector or other arenas to handle medical liability. It's not to say that providers are trying to avoid responsibility, but having special courts and special masters with sophisticated, nuanced understanding of these very technical areas and anatomy and all these other things, I think is important, and to respect that tremendous complexity of the field and the approaches required for really fair outcomes for all parties. I think the proposed rule document also suggests that the injury is not associated with the vaccine itself. In a few places I noticed that, again, suggesting with proper administration that it can eliminate it completely, but they don't provide any direct evidence for that. So we've talked also previously that it's impossible to do a randomized controlled trial for this rare of a condition, and I don't think an IRB would approve such a thing with the existing evidence, just for the ethical considerations. And I had previously mentioned a lot of the articles were indicating a history of a high or deep injection, but these weren't 100%. And so a lot of the injections and cases that we do have were likely performed with proper best practice techniques that we have. And I think the many places like the CDC, pharmacy, training, nursing have all taught these appropriate techniques to providers to help minimize this, and these steps where we still see this at a certain rate. So I don't think if we're to really focus in on this administration and the technique, it's not practical, it's not really cost effective to institute measures that would guarantee that you're within the exact middle of the deltoid. You would really need imaging guidance for every single injection, and that's just not practical. It's beyond the expertise of nursing and pharmacy that do this. It's even difficult for physicians that do this. There are very few individuals like Dr. Boder with a significant ultrasound experience that can be that precise. So the healthcare system in general doesn't have enough physicians to deliver that kind of technique or administration parameters to ensure at 100% rates. And so then you might develop a situation where you're promoting disparities, both racial and socioeconomic, in terms of access to more specialized injections to avoid this. And obviously during a time of renewed struggle for racial equality, I think avoiding anything that would, potentially go down that road is important. I think, too, the practitioners were obviously fundamentally interested in not doing any harm, and many administrators are actually aware of individuals that have had an adverse event. There was an argument in this document talking about, because this is, hidden, you're not aware. You may not be aware of the litigation, but patients will often go back to whoever administered the vaccine initially to tell them that things, haven't gone well, or that initial soreness that one expects after a day or so hasn't resolved. So a lot of administrators are aware when the vaccination didn't produce a standard response. So I don't think this program really affects that. So there is some feedback already built in. I think there's additional risks that I think you've already covered with respect to using private or litigating this in a private system, and malpractice insurance, and potential risk for driving up costs to actually generating these vaccines and delivering them down the road. And I'm glad that Dr. Boder also brought up the new research. So if you look at the proposed rule document, again, states, I quote, "The evidence is thus insufficient to support an adequate causal connection between the contents of any vaccine by themselves and SERVA," end quote. As we discussed, you're never going to have a randomized controlled trial, which is what you would need to assign causation. We're always going to be relying on observational evidence, but now we actually have some epidemiologic evidence, that HESI article and the Tanasoff article that was published this year, along with 2 additional articles published this year in 2020 that have looked into this question of incidence and whether it's more than just a coincidence, as some have argued, that shoulder pain is common, vaccinations are common, therefore the incidence of people having shoulder pain after vaccination is common. And that was looked at by this large database study. And as Dr. Boder mentioned, the incidence is actually reflected at 1 to 130,000 approximately. So the evidence is actually growing, and I think if the Institute of Medicine was reconvened in this year, it would be far more overwhelming and comprehensive to include additional conditions, as Dr. Boder mentioned as well, not just bursitis, but tendinitis, myositis, and other things that might be relevant now that we have this growing observational evidence. And this literature doesn't come from one place. It comes from all over the world. They're all finding the same thing. So I think there's strong evidence with this new incidence findings in the literature that can refute some of the things that were noted in the proposed document about what they were considering excessive number of cases. So if you were to consider the approximately 270 million cases, flu vaccine vaccinations, that would represent at the incidence based on that study of about 2,000 to 2,100 cases. And this would be a conservative estimate considering there's many other vaccinations besides influenza, but that number is well above the claims filed even in the past 3 years combined. And the claims are not, exponentially increasing. The last 2 years were actually fairly stable as a percentage of the SERVA claims. And we would expect this. With increasing awareness of SERVA, there would be an increasing understanding and number of claims. So I think that's important to consider. Education for, I think, we can do our best to educate the administrators and the general public, and that will likely reduce the incidence of SERVA, as the public can advocate for themselves as well. If the public were more aware of this condition and what the proper location is for an injection, I think they'd be more likely to undress instead of kind of being a little reluctant or lazy about taking their shirt off and making sure the deltoid's adequately exposed so they can find the middle of the deltoid and even protect the upper border with their other hand so a vaccinator is not going to do that inadvertently. All these things can help reduce the likelihood of this. And, I mean, we may also just consider not ever using the shoulder. I don't think this is a problem, and as you mentioned, you brought up children, most of these are done in the thigh, and I think they also likely have a greater healing potential and ability to clear things But there are ways to not only work on prevention of SIRVA, but also, as Dr. Boder mentioned, more and more treatment options, particularly if we can identify it early. So I think it's far more likely that SIRVA would lead to conspiracy theories and things if it was removed from the table as if we're trying to hide something, and the government is trying to hide something when it's clearly in the scientific literature from all over the world supporting its existence. So it's far better, I think, to be transparent, to acknowledge that it occurs. We're able to quantify its risk for patients now. It's quite rare. This risk can be mitigated with basic measures by practitioners and patients. And even if it occurs, it's quite treatable, particularly early on with these different treatments that already exist. New treatments are also coming in the pipeline. So I believe most people are really unaware of this program, this injury compensation program. So they're already concerned with medical legal consequences. Taking this on or off the table, I don't think is going to change anybody's incentive on how they act to vaccinate someone. So I think we can eliminate this if we consider the thigh or just eliminate the shoulder as a place. There's no bursa in the lateral aspect of the thigh, and it can handle this. And then tackling this problem head on is far more desirable than trying to sweep it under the rug and cause people's imagination to be far worse than the reality. And I also agree with some of the comments that have been made about alternative options other than removing it from the table. The processes could be improved. They seem to be fairly straightforward administrative things that could be overcome, or adjustments in definitions and rules that are used, or even adjusting compensation if need be. But it doesn't seem like those are so insurmountable that it warrants removing it from the table. So I think overall, removing the SIRVA as a table injury from the VICV would only serve to put the entire weight of this litigation on already overburdened shoulders of health care professionals. So burnout is amongst medical professionals is at an all-time high now. We know that suicide rates among physicians are higher than in the general population. The stress and anxiety of a pandemic continues to wear on this profession in general. And SIRVA as a table injury really promotes vaccination of the general population and protects the healthcare profession. And I really believe it serves the best balance of the interests of both parties. And I think ultimately that's a more equitable way to go. That's all I have. Thank you.
Doctor, thank you for your comments. It was very insightful. Does anybody have any questions for Dr. Srikumarian?
I just want to thank you so much. That was really informative and very helpful. Thank you for the presentation.
Thank you for the opportunity. Appreciate it.
Anybody else? Okay, well, I guess we're going to move on. Doctor, thank you for your time. We truly appreciate it.
Thank you. Take care, guys.
All right. And in reviewing the agenda, it looks like Karen is up.
Okay, thank you for the time. I want to start today by sharing that it's a huge honor for me to be on the ACCV committee. I'm on this board because my daughter was injured by her DPT vaccine at 6 weeks of age in 1994. HHS immediately agreed she was injured. It was a table injury. We settled with the Vaccine Injury Compensation Program in 1998. She died in 2009. I personally wanted to be on this committee so that I could do all that I can to ensure that vaccines are as safe as possible. It is part of the description of our duties from the ACCV Charter that the committee do our best to ensure that vaccine products result in fewer or no significant adverse reactions. To quote our functions of duties under item number 4, survey federal, state, and local programs and activities relating to the gathering of information on injuries associated with the administration of childhood vaccines, including the adverse reaction reporting requirements of Section 300AA-25B of this title, and advise the Secretary on means to obtain, compile, publish, and use credible data related to the frequency and severity of adverse reactions associated with childhood vaccines. I know that we may not all agree on the safety of vaccines and the schedule, but we are here to make sure that the children who are injured are compensated for their injury swiftly and fairly. If you are pro-vaccination, you must be pro-compensation. properly compensate those who are injured for the greater good, we must have appropriate information on the science. I believe that this is our ethical duty as ACCV members. Here are a few reasons I'm asking today that the ACCV committee look into doing a vaxxed versus an unvaxxed study. In 2019, the World Health Organization declared vaccine hesitancy as one of the 10 biggest threats to global health. Currently, no one knows the risk profile with any scientific certainty on the current vaccine schedule. The schedule has never been tested together as it is recommended today by the CDC. There has been a threefold increase in vaccines compared to the 1983 schedule. In 1980, chronic health in children was at 12%, with 10 vaccines given. Today, 69 doses of 16 vaccines are given with chronic health in children at 54%. The safe levels and long-term effects of vaccine ingredients, such as adjuvants and preservatives, are also unknown. The IOM has stated that studies were needed to compare the health outcomes of vaccinated and unvaccinated children to include the timing, age, and load given at one time. A major current controversy is the question of whether vaccination plays a role in neurodevelopment disorders, which broadly include learning disabilities, attention deficit hyperactivity disorder, and autism spectrum disorder. The 2012 IOM report highlighted a key gap in safety science being the lack of public data comparing health outcomes for fully vaccinated versus unvaccinated controls. Even the CDC has conceded this gap in safety science. Parents have been voicing concerns about the safety of recommended immunization schedule as a whole, with opinions that children receive too many vaccines at too young of an age and that the early childhood immunization overwhelms the immune system. This is from the white paper on the safety of childhood immunization schedule vaccine safety data link from 2015. The IOM has complained multiple times that the gaps in safety and limitations in knowledge on vaccine safety, that few existing studies are too small or have inadequate length of follow-up with no reasonable chance of detecting true adverse reactions. In 2012, the IOM Adverse Effects of Vaccines Evidence and Causality report highlighted the key gap in safety science is the lack of public data comparing health outcomes for fully vaccinated versus unvaccinated controls. The childhood immunization schedule and safety stakeholder concerns, scientific evidence, and future studies from the IOM in 2013 identified the lack of baseline data on health outcomes of unvaccinated children as a key gap in safety science, making any science-based statements as to the safety of childhood schedule impossible. The IOM Infant Schedule Study Committee concluded in its 2013 report that few published investigations had specifically examined the safety and recommended childhood schedule as a whole. The IOM report also highlighted 4 research questions of the highest priority to stakeholders. Number 1 was, how do child health outcomes compare between fully vaccinated and unvaccinated children? Vaccination policy in this country depends upon trust between the people and the regulatory authorities. You've all received documents, and one of them has 41 articles that have been peer-reviewed and published on vax versus unvax studies. The first 3 studies are from Dr. Mawson. Also included is Dr. Mawson's CV in his latest report. Dr. Mawson is well-respected and has numerous published peer-reviewed studies. As a commissioner, I would like to invite Dr. Mawson to present his findings from his latest paper published in November 12, 2020, called Multiple Vaccinations and the Enigma of Vaccine Injury. I want to add that Dr. Mawson is pro-vaccine and is committed in finding the safest way to keep children up to date on their vaccinations. His paper discusses children's immune function and why they might be adversely responding to the current vaccination schedule. My hope is that once he shares his studies, that the ACCV commissioners will see how important a vaccinated versus unvaccinated study is to help gain the confidence of the stakeholders. My intention is to first create an interest and then form a work group at the meeting in March 2021. And obviously we're hoping that the board will have a few more members. I just want to remind everyone that the congressional goal of the 1986 Act was to fully compensate those who were injured by vaccines. If we err, it should be on the side of taking care of the injured. I believe this is an important part of performing our charter. And that's my plea. I'd like to ask that we vote today and have Dr. Mawson come in and speak in March and present to us so we can have discussions and everybody can, ask questions and learn more about this. That's what I have to say.
So Karen, thank you for all of that. And I'll tell y'all, Karen and I had talked about this in the work group, and as Dr. Pahud has said, or Barbara has said time and time again, she's not a lawyer, but she's a doctor, and she doesn't understand the lawyer language, but she understands the doctor language. I can tell you that Karen and I are not doctors, and certainly I don't pretend to know as much as Dr. Pahud knows, probably has on the end of her finger and her fingernail compared to what I have. But Karen really grabbed a hold of this project and ran with it, and based on the speech she just gave, you can see that she's put a lot of hard work into this, and I'm in full support. One of the first things that I wish I had done when I came onto this board was to look at the bylaws that really frame what it is that we're supposed to be doing. And this recommendation that Karen is pushing is something that is just dead center in the bylaws, and it's something this commission should be doing. And so I just want to applaud her for digging into this, because it's a complicated issue, I think, for anybody, but certainly for somebody without, medical school background and such, it's even more complicated. So that's my thoughts.
Thank you, John. I think this has been, for the stakeholders, this has been the ongoing question since I joined Vaccine Injury. I think it will create trust. We can look at healthy children as well as children who are not healthy, and there are 41 studies that have already been done, and we could look at as a group and discuss the studies that we would like to talk about. Dr. Mawson is very eager and ready to come share his information. I'd like to create a work group where we have other people, epidemiologists, come in on board, and we have this discussion. And obviously, my goal will be to add the vaccine safety data links. I think I've been told that there was $90 million of taxpayer money for that data link. I'd like to use that, but that's something, I just really want to open this discussion for everybody so we can learn more about it. And I do believe it's part of our purview, and I think it's very, very important.
So, Karen, this is Tamara. So thank you for, organizing this discussion. So when we talked in the work group, one of the things that I had mentioned is that I would reach out to CDC to see what work has been done in this area previously. So Jonathan Duffy has prepared a presentation to kind of discuss what CDC, what has been done in this area in the past.
Great.
So Jonathan, are you ready to present your presentation?
Yes.
Okay. Thank you, Jonathan, for doing this. And okay, I'll let you go.
Okay, thank you. Yeah, so, as stated, I was just requested to provide some background information on what work CDC has done and is continuing to do in regards to studying the safety of childhood immunization schedule. So next slide, please. Oh, okay. All right. So in this presentation, I just first briefly review the 2013 Institute of Medicine report, which was just mentioned, which has informed this work. I'll then summarize briefly the 2016 VSD white paper that outlined the general approach and priorities for studying the safety of the childhood immunization schedule in the VSD. And then finally, I'll describe the various papers VSD has published to date relating to studying the safety of the childhood immunization schedule. So the Institute of Medicine, now known as the National Academy of Medicine, is a private, nonprofit, non-governmental institution operating under congressional charter that works to provide objective evidence on matters of health. The National Vaccine Program Office of the U.S. Department of Health and Human Services asked the IOM to convene a committee of experts in pediatrics, neurology, medical ethics, immunology, statistics, epidemiology, and public health to identify feasible study designs to explore the safety of the U.S. childhood immunization schedule. The committee's report, entitled The Childhood Immunization Schedule and Safety, Stakeholder Concerns, Scientific Evidence and Future Studies was published in 2013 and is freely available online. Next slide, please. The charge to the IOM committee included 2 items. First, to review scientific findings and stakeholder concerns related to the safety of the recommended childhood immunization schedule. And second, to identify potential research approaches, methodologies, and study designs that could inform this question, considering strengths, weaknesses, as well as the ethical and financial feasibility of each approach. In the IOM report, the childhood immunization schedule is defined as the immunization schedule covering children from birth through age 6 years. Next slide. So the report stated, even though the vast majority of parents adhere to the ACIP recommended immunization schedule, some parents are concerned that the schedule may present unnecessary risks because of the timing and number of vaccinations. And the report identified the following 4 leading research questions of interest to selected stakeholders. So first, how do child health outcomes compare between those who receive no vaccinations and those who receive the full currently recommended immunization schedule? 2, how do child health outcomes compare between those who receive the full currently recommended immunization schedule and those who omit specific vaccines? And 3, children who receive the currently recommended immunization schedule, do long or short-term or long-term health outcomes differ for those who receive fewer immunizations per visit or for those who receive their immunizations at later ages but still within the recommended ages? And 4th, do potentially susceptible subpopulations who may experience adverse health outcomes associated with immunization with currently recommended immunization schedules exist? Next slide. So this slide just highlights a few selected conclusions stated in the IOM report. So first, there are concerns from some stakeholders that merit exploration through research if epidemiologic signals are detected and an indication of biological plausibility is available. Second, however, the committee concludes that it is not ethical to implement any study requiring that some children receive fewer vaccines than recommended as part of the childhood immunization schedule, because this would needlessly endanger children's lives. And finally, thirdly, the committee concludes that data from existing surveillance systems, such as the Vaccine Safety Data Link, could be used and offer the best means for ongoing research efforts regarding the safety of the schedule. Next slide. So guided by the IOM report's findings, the CDC's Immunization Safety Office commissioned VST investigators to develop a white paper to assess how the VST could be used to study the safety of the childhood immunization schedule. So as a reminder, the Vaccine Safety Data Link is a collaboration between the CDC and 8 integrated healthcare organizations that was originally established in 1990. The VSD currently has access to medical care and demographic data on over 12 million persons annually. And just mention that, the number of participating organizations and the size of the population has changed over time. So next slide. So the white paper on studying the safety of the childhood immunization schedule and the Vaccine Safety Data Link was developed and written between September 2013 and December 2014, and was published in its final version in the journal Vaccine in February 2016. The process used to develop the white paper involved reviewing the IOM report in detail, conducting a review of published literature, and meeting with vaccine subject matter experts. Next slide. The white paper addressed 3 separate but related content areas. So these are, first, defining exposure to different immunization schedules. Second, identifying health outcomes to study in the context of the immunization schedule. And third, describing epidemiologic and statistical methods to study the safety of the schedule. So in the next few slides, I'll highlight a few findings from each content area of the white paper. So the first content area, defining exposure to different immunization schedules. The paper notes that undervaccination is broadly defined as children who are either behind on their immunizations or on a schedule that differs from the recommended schedule. Second, the comparisons of undervaccinated children to children who are age-appropriately vaccinated poses numerous methodological challenges that can threaten the validity of future safety studies, including information bias, confounding, and lack of statistical power. And then in the white paper, the paper describes a 4-staged approach for identifying cohorts of undervaccinated children for safety studies. Next slide, please. So in the second content area, which was identifying health outcomes to study, a 3-phased approach was used to identify, categorize, and prioritize outcomes for future safety studies in the VSD. And based on the IOM report, the focus was on identifying plausible health outcomes that could be evaluated in the context of the schedule as a whole. And second, the importance of studying longer-term outcomes such as autoimmune diseases, asthma, and other allergic conditions. Next slide. So in the third this slide shows the final list of outcomes that were included in the published white paper, and these were identified through a process of subject matter expert engagement, and were ranked based on feasibility, public health significance, and public concern. So next slide. So this is the third content area, the methods to study the safety of the schedule. So just 3 points here was that observational immunization schedule safety research could be prone to potential sources of bias, including unmeasured confounding, healthcare-seeking bias, reverse causality, selection bias, and misclassification of exposures and outcomes. So the white paper describes several methods to help address these biases, and the white paper describes various study designs and methods that can be used to analyze the safety of the schedule. So next slide. So the white paper concluded that while it appears feasible to study the safety of the recommended immunization schedule in settings such as the VSD, these studies will be inherently complex, and as with all observational studies, will need to carefully address issues of confounding and bias. And that the VSD investigators are able to use this document as a guide when designing and conducting studies of the safety of the childhood immunization schedule if such studies are judged to be necessary. So in summary, the white paper outlined the directions for future research. So next slide. So the VSD had begun some studies related to the immunization schedule prior to publication of the IVR report and the VSD white paper, and additional studies have been completed and published since then. Since 2013, VSD has published 13 studies related to the immunization schedule, which I'll briefly summarize in the next few slides. So this first one I want to highlight was one of the first schedule-related VSD studies published in 2013, and its objective was to examine patterns and trends of under-vaccination in children aged 2 to 24 months and to compare healthcare utilization rates between under-vaccinated and age-appropriately vaccinated children. So, again, this was a starting point of sort of understanding the vaccination patterns in the VSD population. And this study found that among over 300,000 children born between 2004 and 2008, almost 49% were under-vaccinated for at least one day before age 24 months. And that when compared to children who were age-appropriately vaccinated, under-vaccinated children had lower outpatient visit rates and increased inpatient admission rates. And also that children who were under-vaccinated because of parental choice had lower rates of outpatient visits and emergency department encounters. So this paper concluded that under-vaccinated children appear to have different healthcare utilization patterns compared with age-appropriately vaccinated children. And the next slide just shows one of the other findings from this paper, which are that 2.8% of children appeared to be on specific non-standard vaccination schedules, and approximately 1% of children who had no record of receiving any doses of 8 recommended vaccines before age 2 years. And the figure just shows that how these percentages had changed over the years included in the study. So next slide. So in the interest of time, I just list the other VSD papers related to schedule by broad categories of the issues that they address without going into as much detail about each paper, but details can be found using the web links provided on the slides. So the first category is just broadly papers that address methodological issues related to studying the schedule. So the issues addressed include data misclassification of vaccine exposure or adverse event outcomes, and examining ways to define exposures to the vaccine schedule in terms of number of vaccine antigens, number of vaccines, or the vaccine aluminum content. I'd just highlight that one of these studies was a survey of parents of children aged 19 to 35 months with the objective to determine the agreement between health record vaccination data and parent-reported vaccination status. And the survey found that among children who had no records of receiving any vaccines, the observed agreement between parent-reported and electronic health record data was 94%. So again, these methodologic studies are just sort of laying the groundwork for understanding the data and planning how to do future studies. Next slide. So other papers have addressed the risk of specific adverse event outcomes based on exposure to various aspects of the immunization schedule. So the outcomes studied to date have included autism, other neuropsychological disorders, death, and non-vaccine targeted infections, which just mention is considered a potential surrogate outcome for the concern of non-vaccine effects on the immune system, or concerns that vaccines may weaken the immune system for other types of infections. And none of these studies found an increased risk of any outcomes that were understudied for the vaccine exposures that were included. So next slide. One paper to date has assessed the risk of vaccine preventable disease, specifically the risk of pertussis infection among children who did or did not receive DTaP vaccine according to the recommended schedule. And then next slide, there's also been one paper published to date that has assessed vaccination patterns in children after autism spectrum diagnosis disorder and in their younger siblings. Next slide. So there's point out that in addition to the studies already mentioned that focus on different aspects of the vaccination schedule, VSD studies have, when feasible and appropriate, compared the risk of certain outcomes among children who have received a specific vaccine to those who do not receive the vaccine. So this is looking at, risks associated with individual vaccines. And 3 examples here involve vaccines for hepatitis B, rotavirus, and varicella. So next slide, in summary, the Institute of Medicine identified the CDC's Vaccine Safety Data Link system as one of the best resources for research regarding the safety of the childhood immunization schedule. Observational studies of the immunization schedule pose numerous methodological challenges and require careful planning to control for potential sources of bias. To date, the VSD has completed many studies related to the immunization schedule, and additional VSD studies of the immunization schedule are ongoing and planned to address the priorities outlined in the VSD white paper. That concludes my presentation. Thank you.
Thank you so much. And so that's why I really would like to work together with the CDC and go over more current reports. I mean, I've read most of the reports that you mentioned here in your presentation, and often the IOM is saying that, there still needs to be gaps that are closed, and that's what I would like to do in March, have you and have Dr. Mawson and create a panel that we have this discussion and go over how it is to use the vaccine safety data link. I mean, we spend millions of dollars on this program, and I believe that there's no more important time than now to secure the stakeholders' trust with the COVID vaccine and the vaccine schedule. I guess I'm asking that the board vote if everyone agrees that Dr. Mawson should present and open this discussion in March 2021.
So is Barbara on the phone?
I'm here.
Okay.
What about me? Are you not going to ask about me?
No, I was just making sure because I had not heard.
I'm just playing with you.
I was just making sure.
I hate to. I'm not going to be able to be there, but I would vote in favor.
Thank you, John.
And we're voting on hearing from Mawson?
Yes, we're voting on inviting Dr. Mawson to come, and he just wrote a November study, and I'd like to have him discuss that study, discuss his opinion, and Dr. Brian Hooker has just written a study, and Dr. James Lyons and Dr. Paul Thompson have just done a study, but I thought I'd baby step it and have Dr. Mawson come in and give us a chance to really understand the importance of why we need to do this study. And I would like to independently use the vaccine safety data link because, of course, that's what taxpayers are paying for, that information, and to be used. And I feel like it's part of our purview, and I think it would definitely secure the stakeholders right now. I don't think there's ever been a time that people are questioning vaccines more.
Yeah, I think that's great. I would be in favor of that.
Thank you.
Barbara?
Sure, they can come, but again, I don't see how this is going to lead us anywhere, so it's fine with me, but I'm still not seeing the end of the tunnel. If they do come, I suggest we invite 2 other researchers that are used to using the VSD database. So I could propose a couple of people, Sad Omar or Daniel, help me, somebody from the call, Daniel Solomon maybe, so that we can have somebody else that has experience working with VSD present on the call maybe.
That would be great, and Dr. Brian Hooker has experience, and he'd be more than welcome to join the call. And he has just done another study, but he has used the vaccine safety data link with the Guyers, Dr. Guyers. All right, thank you. I will definitely make sure that it has a lot of information, and we can invite everybody. And from there, I'm hoping that we have more people on the committee, and then we can start a work group. I know right now is a critical time for everybody, and it's very busy, but this is really, I think, one of the most important reasons that I came on the board.
So are we on to our next piece of business, or do we need to, Mara?
No, you all have basically agreed to invite these various speakers to the March meeting, so that's fine. We can move on.
Okay, and then Mr. Duffy, Dr. Duffy, is the presentation you just gave the same one that you're up on the agenda for next?
No, my next presentation is just the routine
Gotcha.
updates.
Okay, if you're ready to go, we're ready.
Okay. I think I can control the slides, so I think I may be able to advance these myself. So again, this is just the sort of routine update on immunization safety office activities and sort of vaccine-related information from CDC on things that have occurred since the last ACCV meeting. So I just first wanted to highlight some recent publications from the CDC's Immunization Safety Office. So this first one was a paper about adverse events following Menactra vaccine reported to the Vaccine Adverse Event Reporting System. So just to summarize very briefly, Menactra was licensed in 2005 and is a quadrivalent meningococcal conjugate vaccine. And it's licensed for individuals aged 9 months through 55 years. So this was a paper that reviewing VAERS reports related to that vaccine from 2005 through 2016. There had been early reports about this, but this was a longer-term follow-up of reports to VAERS. And so over that time period, there are more than 13,000 reports of adverse events following Menactra vaccination. 94% were classified as non-serious. And so in summary, this review did not reveal any new safety concerns regarding this vaccine. So the second publication is entitled Guillain-Barré syndrome following high-dose influenza vaccine administered in the United States for the 2018-2019 season. And this paper was a joint collaboration between CDC and the Food and Drug Administration. And so, again, just a brief summary is that Guillain-Barré syndrome has been recognized as an adverse event following influenza vaccines since 1976. And so surveillance for Guillain-Barré syndrome is conducted in each influenza season, and it's not, a risk isn't necessarily observed every year. But in the 2018-2019 flu season, the Vaccine Safety Data Link identified a statistical signal for an increased risk of GBS following high-dose flu vaccine. And then subsequent to that, the FDA led an investigation to evaluate that signal using Medicare data. And in the final analysis, neither analysis showed a statistically significant increased risk, and it was concluded that if a GBS risk existed, it was similar to that had been observed in prior influenza seasons. The third paper here was one evaluating the association of stillbirths after maternal vaccination in the Vaccine Safety Data Link. And so this was a paper looking at Tdap vaccination and influenza vaccination, other vaccines that are recommended in pregnancy. And it's basically a case control study comparing stillbirths to women who have live birth, and essentially found no difference in vaccination history and concluded that that there was no safety concern and that this information supports the current recommendations for vaccination during pregnancy. And the fourth paper to highlight here is entitled The Reporting Sensitivity of the Vaccine Adverse Event Reporting System for Anaphylaxis and Guillain-Barré Syndrome. So just a brief summary is that underreporting is an important limitation that is common to passive surveillance systems, such as VAERS. So the goal of this paper was to determine the sensitivity of VAERS to capture reports for anaphylaxis and Guillain-Barré syndrome. And so this was done by estimating the expected rate of adverse events based on studies from the Vaccine Safety Data Link, and then determining what the potential reporting rate was in VAERS. And so it found that VAERS sensitivity for capturing anaphylaxis after 7 different vaccines ranged from 13 to 76%. And the sensitivity for capturing GBS after 3 different vaccines ranged from 12 to 64%. And so, compared to previous evaluations, this was concluded that VAERS sensitivity is comparable to estimates for other serious adverse events. So now I'll just transition to talking about updates from the Advisory Committee on Immunization Practices. So in October, the ACIP held a 3-day meeting that addressed a variety of topics. And just on each slide, I'll just highlight very briefly what are the main points from each topic. So there was a vote to approve changes to the recommended immunization schedule. This is a the immunization schedule is updated every year, and so this just reflects any changes that were voted on during the 2020, and the updated schedule will be released in February 2021. Seasonal influenza vaccines were discussed. There was a presentation on the efficacy of Flucelvax quadrivalent vaccine in children aged 2 to 17 years. This was presented by the manufacturer of the vaccine, Securus, and is reporting results of the phase 3 trial that found that overall vaccine efficacy was 54%. And CDC also presented information on influenza disease burden for the 2019-2020 season, that there was an estimated 38 million illnesses and 22,000 deaths associated with influenza in that season. And then also estimates on influenza vaccine impact for that season, which estimated that influenza vaccine in the United States prevented 7.5 million illnesses, 100,000 hospitalizations, and more than 6,000 deaths. There was a session on orthopox virus vaccine. So the key point is that monkeypox is considered a global threat. There are cases that occur in Nigeria and the Democratic Republic of Congo, and secondary transmission can occur to healthcare workers. So the Jynneos vaccine is a live attenuated non-replicating vaccine that is approved in the United States in 2019 to prevent smallpox and monkeypox disease in adults. And so the policy question that ACIP is considering is whether this vaccine should be recommended for persons who are at risk for occupational exposure to orthopox viruses. And so ACIP will continue to discuss the data and vote on this issue in 2021. There was also a session discussing dengue vaccine. Dengvaxia is a vaccine that was approved in the United States about a year ago to prevent dengue infection in persons in endemic areas. And so the issue under discussion is whether to recommend this vaccine for a phased approach in Puerto Rico, where dengue is endemic. And so the discussion around this is around the key point that performance of pre-vaccination screening tests for prior dengue infection are a key determinant in deciding this policy. And so ACIP again is going to review more information and plans to vote on recommendations next year. There's a presentation on pneumococcal vaccines. So currently there are 2 different pneumococcal vaccines approved in the United States. One is the polysaccharide 23-valent vaccine, and the other is the 13-valent conjugate vaccine. So this session discussed that there are 2 new PCV products on the horizon, a PCV15 and a PCV20 formulation, and licensure may occur as soon as 2021. And so the ACIP will review considerations and evidence supporting the use of new vaccines in adults. And then it was stated that licensure for children may occur in 2022 or 2023. There's also a discussion of cholera vaccine. So in 2017, ACIP recommended cholera vaccine for adult travelers to areas of active cholera transmission. And so the current discussion in the work group is whether recent pediatric data will inform whether ACIP should recommend cholera vaccine for travelers aged 2 to 17 years. There's also a session on zoster vaccine. ACIP has recommended the recombinant zoster vaccine since October 2017. And the older live zoster vaccine is no longer sold in the United States as of this last July. And so this session provided updates on post-licensure safety monitoring of the newer recombinant zoster vaccine in both VAERS and VSD. And key points here are that there's potential risk of Guillain-Barré syndrome observed for recombinant zoster vaccine. There's also noted that separate studies have observed an increased risk of GBS following herpes zoster infection, which is what the vaccine is meant to prevent, and that at future ACIP meetings there will be discussions of a risk-benefit analysis related to this vaccine. There was also a session on tick-borne encephalitis vaccine. So it was stated that Pfizer plans to submit a biologics license application to the FDA for a TBE vaccine, with licensure again possible in 2021. Tick-borne encephalitis is a disease that is endemic in parts of Europe and Asia, and ACIP will plan to consider the use of the vaccine if it's licensed in the United States for U.S. adults and children visiting or living in endemic areas and in laboratory workers. There's also a session on rabies vaccine, and in brief, ACIP is considering updates to the pre-exposure prophylaxis vaccine dosing schedule and to clinical guidance on risk groups and And this is, again, a topic under further consideration and discussion planned at future meetings. So then in this next section, I just want to transition to COVID vaccines, which were discussed at both an emergency meeting in September and the October meeting. And then since these slides were prepared and submitted for this meeting, there were also 2 additional ACIP meetings to discuss COVID vaccines in November and then one earlier this week. So the update on the vaccines is that there are 4 vaccines in active phase 3 clinical trials in the United States listed here on the slide for COVID-19. And that ACIP outlined these meetings, their path to creating a COVID-19 vaccine recommendation. So just briefly, the work group is meeting weekly for the ACIP COVID-19 work group to review data. And once data are available from phase 3 clinical trials, the work group will conduct an independent review of the safety and efficacy data. And based on that data, we'll present policy options to the full ACIP. And if and when FDA decides to authorize one of these vaccines, ACIP will have an emergency meeting with a public comment session to vote on recommendations for vaccine use. And after such a vote, those ACIP's recommendations are submitted to the CDC director, and if they're accepted, then they'll be published in the MDR and become official CDC policy. So that's just an outline of the future plans. And then, again, at the October ACIP meeting, there was this slide just outlines the various discussions that took place around COVID vaccine development, implementation, plans for safety monitoring, allocation, and then the policy options that ACIP was considering. So from a safety standpoint, I just wanted to spend a few moments highlighting some of the CDC post-authorization and post-licensure safety monitoring plans for the COVID vaccine. So CDC systems, the VSD, the CISA project, and other monitoring systems are planned. So VAERS, just as a reminder, is the frontline vaccine safety monitoring system. And one of the key points that was presented was that healthcare providers play a key role in identifying and reporting potential adverse events to VAERS. And there was also information presented on vaccine safety assessment for essential workers. There's a new system that has been created called vSafe, which uses smartphone technology to do active vaccine safety surveillance. And healthcare partners can also play an important role in the future when this is rolled out by helping CDC enroll people who have been vaccinated with COVID vaccines into this new reporting system. So this slide just summarizes some of the information about vSafe. It uses text messaging to initiate web-based survey monitoring, conducts electronic health checks on vaccine recipients, and includes active telephone follow-up through the VAERS program with vaccine recipients who report clinically important events during their health checks using the vSafe system. And information was also presented at the October ACIP meeting on how the vaccine safety technical subgroup of the ACIP work group will be transitioned into a data review group. And this was noted that built off lessons learned from the 2009 H1N vaccine safety monitoring, that this was felt this would provide a transparent, independent, and public accountable process for reviewing safety information. So this group is going to be composed of members from ACIP and NVAC, with 7 independent expert consultants and ex officio members from other government agencies. And so the objectives here are to review, evaluate, and interpret post-authorization or post-approval COVID-19 vaccine safety data and serve as a central hub for technical subject matter experts from federal agencies conducting vaccine safety surveillance to share that surveillance data. And it will advise on analysis, interpretation, and data presentation, and work with the ACIP COVID-19 vaccines work group on issues of safety and presenting that to the ACIP for policy decisions. And so the deliverables for this group are proposed to be frequent vaccine safety technical reports for internal ACIP and CDC and federal partner use, and frequent vaccine safety summaries for public release. And so, again, not included in the slides, but just earlier this week, ACIP did hold a vote on priority recommendations for, if and when a vaccine for COVID-19 becomes available. It outlined a a policy recommendation that healthcare workers and residents of long-term care facilities be considered the groups for priority vaccination when a COVID vaccine becomes available. So that concludes my presentation. I'm happy to take any questions.
I have a question that I understand you may not have the answer to, but wonder if I can try.
Okay.
So do you have any insight as to how they intend to continue to evaluate phase 3 data of all these people that have been enrolled in these clinical trials, 30,000 for, vaccine, and then once the vaccines become available under emergency use, they're going to get vaccinated, so we'll have to change the clinical trial analysis to account for this. So do you have any insights as to how they intend to do this? Because without those phase 3 trials completed, it'll be kind of impossible for us to get complete approval of the vaccines, not under emergency use, but under regular use, by providing all the safety data that we normally collect from these vaccines. But I understand that there are difficult times and we need to provide the vaccine to the public, but we also need to finish the clinical trials. It's kind of like we're shooting ourselves in the foot, but I understand why we're doing it. So I'm just curious to know if you have any insights or if it was discussed at ACIP.
Well, yeah, I mean, I think that issue has been raised, and I don't think I'm not aware that a conclusion has been reached. But FDA's VRBPAC will be meeting to discuss the individual vaccines, and then ACIP after that will hold additional meetings to discuss additional recommendations for the vaccine. So I'm sure that issue will be addressed again in the future.
Thank you.
Does anybody else have any questions for Dr. Duffy? Well, Dr. Duffy, we appreciate your time. Thank you very much for being here today.
You're welcome.
And moving on to Claire Schuster. Ms. Schuster, are you ready to go?
Yep.
All right.
All of my slides.
Yes.
Okay, it looks like they're not advancing. I might need your help advancing them for me.
Okay, no problem. I'm here.
Okay, great. Thank you. Hi, I'm Claire Schuster, and today I will be presenting the update for the National Institutes of Health. And I'll start with a few updates on our COVID-19 vaccine research. In March 2020, NIAID launched a phase 1 clinical trial to evaluate the investigational mRNA 1273 vaccine designed to prevent SARS-CoV-2 infection. The vaccine was co-developed by researchers at NIAID and Moderna, Inc. The phase 1 trial began with participants between 18 and 55 years of age and was later expanded to include older adults between 56 and 70 years of age and ages 71 and older. Among the older age groups, the trial evaluated 2 different doses of vaccine. These results were published in the New England Journal of Medicine in September. Overall, the researchers found that the investigational vaccine was well tolerated in the older age group. Although some volunteers experienced some transient adverse effects, including fever and fatigue after vaccination, they also generated a good immune response to the vaccine. These results helped to lay the foundation for subsequent clinical testing of the same vaccine, which I will discuss further in the next slide. Next slide, please. A variety of different platforms are being explored for COVID-19 vaccine development. This slide shows the platforms grouped into 3 categories: nucleic acid, viral vector, and protein subunits. We'll start by looking at the nucleic acid platform. Vaccines from Moderna and Pfizer-BioNTech use mRNA technology with a 2-dose regimen. And as you've probably heard, both companies have recently announced early results from their phase 3 trials. Both vaccines were reported to be well tolerated with a vaccine efficacy of approximately 94 to 95%. In recent company press releases, Moderna and Pfizer shared the following safety information. For Moderna, based on prior analysis, the most common solicited adverse reactions included injection site pain, fatigue, myalgia, arthralgia, headache, and redness at the injection site. For Pfizer, the only grade 3 adverse events reported at greater than 2% in frequency were fatigue and headache. Both companies have submitted a request to the FDA for emergency use authorization. And a recent development since our last meeting is that Pfizer has now started testing their vaccine candidate in children as young as 12 years of age, and Moderna has also indicated that they will be testing their vaccine in children between the ages of 12 and 17. For the viral vector platform, these vaccines use a modified, non-replicating virus to deliver a SARS-CoV-2 spike protein to induce an immune response. Phase 3 trials in the U.S. are underway for AstraZeneca's candidate, as well as an investigational vaccine developed by Janssen Pharmaceutical Companies of Johnson & Johnson. On November 23rd, AstraZeneca announced results from trials in the UK and Brazil, reporting on 2 different dosing regimens. One dosing regimen showed a vaccine efficacy of 90% when the vaccine was given as a half dose followed by a full dose at least 1 month apart. Another dosing regimen showed 62% efficacy when given as 2 full doses at least 1 month apart. For the Janssen trial, I wanted to note that unlike the other trials mentioned, this study is evaluating a single dose regimen. For the protein subunit platforms, this strategy uses small pieces of the virus's protein to generate an immune response. U.S. phase 3 trials for COVID-19 vaccines using this platform have not yet begun. Next slide, please. Now I'll discuss some of the ongoing research for COVID-19 treatment. In April, NIH announced the Accelerating COVID-19 Therapeutic Interventions and Vaccines, or ACTIV, public-private partnership. ACTIV aims to develop a coordinated research strategy to prioritize and accelerate development of promising treatments and vaccines. Several trials are underway to evaluate different treatment options. A study known as ACTIV-1 is evaluating immune modulator drugs in hospitalized adults with COVID-19. ACTIV-2 is an outpatient trial to evaluate new therapeutics for COVID-19, including monoclonal antibodies. ACTIV-3 is a master protocol to test different monoclonal antibody treatments in hospitalized patients. The first product tested in this trial was a monoclonal antibody known as LY-CoV555, which was developed and manufactured by Eli Lilly and Company in collaboration with Accelera Biologics. On October 26th, an independent data and safety monitoring board recommended no further participants be randomized to receive this investigational monoclonal antibody. This recommendation was based on the fact of a low likelihood that this intervention would provide clinical benefit to hospitalized patients. ACTIV-4 is a master protocol looking at different types of blood thinners to treat patients with COVID-19. Next slide, please. In October, NIAID launched a study designed to determine whether certain approved therapies or investigational drugs in late-stage clinical development show promise against COVID-19 and merit advancement into larger clinical trials. This study is known as ACTIV-5, the Big Effect trial. The first products being evaluated in this study are the monoclonal antibody risankizumab and the investigational monoclonal antibody blinzilumab. Each monoclonal antibody will be tested in combination with remdesivir. Risankizumab was approved in the U.S. in 2019 to treat severe plaque psoriasis. Blinzilumab is currently being tested separately in a phase 3 COVID-19 study and in a phase 1b/2 study as a sequential therapy with CAR T treatments for cancer. Next slide, please. Now I'm going to provide updates on additional disease areas supported by NIAID. EVD68 is part of a family of viruses known as enteroviruses that are thought to cause a condition known as acute flaccid myelitis, or AFM. AFM is an uncommon but serious neurologic condition. Most cases have been in young children. It affects nerve tissue within the spinal cord, causing muscle weakness and paralysis. We've seen increases in AFM cases in the U.S. every other year starting in 2014. At a previous ACCV meeting, I mentioned an ongoing NIAID-supported study to learn more about the incidence and distribution of AFM cases and to better understand how the disease develops and progresses in children. Today, I also wanted to share a more recent update, specifically that in September, NIAID awarded a contract to the company Intravax for development of an EVD68 vaccine candidate. This project focuses on development of a vaccine to protect children from AFM. Next slide, please. So while this update is not related to vaccine, I thought the group would be interested in hearing about this pediatric research advance. An NIAID-sponsored clinical trial has shown that short course or 5-day antibiotic treatment is superior to standard 10-day treatment of community-acquired pneumonia, CAP, children ages 6 months to 5 years. It's important to note that both treatment strategies were effective in treating CAP. These findings could result in shortened effective treatment times for the sometimes serious childhood infection, thereby reducing the risk of development of bacterial resistance to antibiotics and decreasing children's antibiotic exposure. Next slide, please. And lastly, as the research landscape is changing very quickly, I would encourage everyone to the NIAID websites, including the NIH Director's blog, and our social media presence on Twitter and Facebook. And with that, I'd like to thank our commissioners for all of their time and thoughtful discussion at these meetings, and to thank John for several years of service with ACCV, and I'm happy to take any questions.
Thank you so much. I have a couple questions. This is Karen. I've heard and I've read about the temperature of the vaccine, which, can you just clarify? I mean, I don't know if all the vaccines are the same way, but there was one vaccine they were talking about has to be -70, kept at a temperature rate to be effective. Is that true for all the vaccines? And if so, how do they plan on keeping that temperature when delivered all over?
Thanks. I'll respond, but I'll welcome input from my CDC and FDA colleagues. So I think so far we've seen different requirements in terms of keeping the vaccines cold for the cold chain, where it's true that there are some that require ultra cold refrigeration at -70, others at -20. So there are differences across the different candidates, and those are important considerations for when the vaccines are rolled out.
And so in the U.S. at least, because I think in Ireland or England, they say the vaccine is out now. And so as Dr. Boho was saying, you know, are we in the U.S. not going to roll this out until the phase 3 study has been completed?
So maybe Valerie can weigh in for FDA, but
yes, I was actually going to cover some of the emergency use authorization process during my slides. Following the authorization of an EUA, then that would trigger the process by which the vaccines would be distributed.
Okay, thank you so much. I think I did. Oh, and so how, I mean, who should I ask this question to? Obviously, this is what everyone is talking about. Will this be mandated?
Yeah, I've only seen what's been reported in the media myself on that question.
And it will also depend on where you work. I mean, government can't, I don't believe the government will necessarily mandate that, but if you work at a healthcare facility or nursing facility, then those particular organizations may have some type of mandate.
Is that even before the phase 3 study is done?
Well, that's at the point where the emergency use authorization has been approved.
Wait, I heard what you said, but I don't understand what you're saying.
So following the emergency, if the FDA issues an emergency use authorization, at that point, I don't know how the legal process works, But at that point, if a hospital or whatever type of organization may try to have some types of mandates, I haven't necessarily heard that.
Karen, I can tell you that at least in my hospital, and I'm sure it'll be the same across all hospitals, it's impossible to mandate something when we don't have enough vaccine. So we don't know how much vaccine will be available, and phase 3, like I said, has not been completed. So usually emergency use authorizations vaccines in the past have never been mandated. What could happen, and this is again just me speaking as a civilian, not as a member of anything, what could happen though, and we have seen it in the news, is that a particular, for example, airline may say you cannot fly unless you're vaccinated because they're trying to protect the other passengers. So they can impose their own mandates because it affects their business, but it's going to be very hard, I think, for any government to say this is mandated without having enough vaccine to provide for anyone, because how can you mandate something that's not widely available?
That's a great comment. And, I mean, I think that's, the biggest concern. And it's very interesting because I've flown many, many times in the last month, many airlines, and American is definitely the strictest. So if they mandate that you have to have the vaccination and you're injured because of the countermeasure program, you actually sue the airlines, which I'm wondering if they understand.
We're so long from that, Karen, because there's not enough vaccine right now. So those are conversations probably for a year to two from now.
So Karen, that sounds far away, but it is, it's a huge concern for the stakeholders. And thank you so much for that information.
Hey, Karen, this is Tamara. So for compensation, they would actually be filing a claim with a compensation program, not against the vaccine, not against the airline if they're injured by COVID vaccine.
But didn't we talk about this last time where you said that you have to go after the place that made it mandatory for you to get the vaccine? Isn't that what the countermeasure program means?
No, that's not what it is. No, I will, in my presentation, you'll see, but no. With the countermeasures program, they would be filing a claim with the program and basically filing a claim with the federal government for their alleged injury.
Oh, I thought that what I understood last meeting was that when you go into the countermeasures program, if you have to get the vaccine for work or I guess for flying, then you would file your countermeasure lawsuit, but then you would actually file it towards the person that made you get the vaccine. So I misunderstood. I'm looking forward to your presentation. Thank you.
Okay, does anybody have any additional questions for Ms. Schuster? All right, well, thank you, Ms. Schuster, for your time. We really appreciate it. Valerie, are you up?
Yes.
All right.
Right.
Fire away.
All righty. Annie, would you mind forwarding my slides? Actually, let me see if I can do it. Okay, yes, I can. So good afternoon. I am Valerie Marshall, and I'm pleased to be with you to share an update from the Office of Vaccines Research and Review within the Food and Drug Administration. On Thursday, December 10th, the FDA will meet in open session to discuss the emergency use authorization for Pfizer-BioNTech COVID-19 vaccine. The meeting will be webcast via multiple platforms, including YouTube, Twitter, and FDA Yourcast. The meeting details can be found at the website posted on my slide. And you can also find the meeting details by just Googling Pfizer VRBPAC meeting. Since submitting my slides, we actually have another VRBPAC meeting planned, and that's on December 17th, where we will discuss emergency use authorization for COVID-19 vaccine manufactured by Moderna. So we have these two products back to back. Pfizer will be on the 10th, followed by Moderna on the 17th. Because the VRBPAC meetings will focus on emergency use authorization of specific vaccines, I wanted to provide more details about emergency use authorization in general and how the process should flow. On February 4, 2020, the Secretary of HHS determined that there is a public health emergency that has a significant potential to affect national security or the health and security of the United States citizens living abroad, and that was caused by COVID-19. On the basis of that determination, on March 27th, the Secretary then declared that circumstances exist justifying the authorization of emergency use of drugs and biological products during the COVID-19 pandemic. These declarations that I just mentioned were necessary to open a path for emergency use authorization. So emergency use authorization is a mechanism to facilitate the availability and use of medical countermeasures, including vaccines, during public health emergencies such as the current COVID-19 pandemic. In August of this year, an EUA was issued for remdesivir, which was used to treat COVID-19 in hospitalized and pediatric patients. Under an EUA, the FDA may allow the use of unapproved medical products to prevent serious or life-threatening diseases when certain statutory criteria have been met, including that there are no adequate, approved, and available alternatives. The SARS-CoV-2 pandemic presents an extraordinary challenge to global health, and there are currently no FDA-licensed vaccines to prevent COVID-19. So taking into consideration input from the FDA, a manufacturer decides whether and when to submit an EUA request to the FDA. Once submitted, the FDA will evaluate the EUA request and determine whether the relevant statutory criteria are met and review the scientific evidence about the vaccine that is available to the FDA. COVID-19 vaccines are undergoing a rigorous development process that includes tens of thousands of study participants to generate the needed non-clinical, clinical, and manufacturing data. So for an EUA to be issued for a vaccine, specific requirements must be met. Adequate manufacturing information to ensure quality and consistency. And as I mentioned previously, the COVID-19 vaccines are undergoing a rigorous development process. And from that clinical data, the FDA must determine that the known and potential benefits outweigh the known and potential risks of the vaccine. And this is based on one well-designed phase 3 clinical study that in a compelling manner demonstrates safety and efficacy. And the safety data may be from throughout the clinical development from phase 1, 2, and 3, which includes well over 3,000 phase 3 vaccine recipients, which will evaluate reactogenicity, serious adverse events, and adverse events of special interest. So this is a very high-level slide that visualizes the EUA process. Clinical trials are conducted, which generate safety and effectiveness data for a particular vaccine. When the phase 3 portion of the clinical study reaches a predetermined point that informs how well a vaccine prevents COVID, an independent group reviews the data and informs the manufacturer of the results. And what we've seen in the news recently are Pfizer and Moderna announcing over 90% effectiveness for their particular vaccines. So the company or the sponsor reviews data to determine whether the company's scientists and technical experts believe that the vaccine meets the FDA's outlined expectations for safety and effectiveness. The company then decides to submit a request for emergency use authorization. Once submitted, the FDA will evaluate the EUA, taking into account the totality of the scientific evidence about the vaccine, and that includes chemistry, manufacturing, and controls, which ensure the quality and consistency of the vaccine product. The FDA then convenes the Vaccines and Related Biological Products Advisory Committee to discuss the data. Following the advisory committee meeting, FDA staff consider the input and continue their evaluation to determine whether the available safety, effectiveness, and manufacturing data support emergency use authorization. If FDA determines that the criteria for EUA are met, including that the known and potential benefits outweigh the known and potential risk of the vaccine, and that manufacturing information is adequate to ensure its quality and consistency, the FDA may then authorize the vaccine for emergency use. And at that point, the FDA would inform the company that their product has been authorized. So FDA, so this slide shows plans for continued monitoring of COVID-19 vaccines authorized by FDA. The FDA expects vaccine manufacturers to include in their EUA requests plans for active follow-up and surveillance. Other USG systems that we are familiar with include VAERS, VSD, the Biologics Effectiveness and Safety Initiative, and Medicare claims data. So these are just two helpful websites that outline the FDA vaccine development process, and also the second link is a link that describes emergency use authorization in very great detail. So this concludes my presentation, and I'm happy to take any questions.
Valerie, this is John Howie. I have a question for you.
Sure.
At what point does more specific information about adverse events become available to the general public? I mean, you hear about, you know, most adverse events were mild and it was mild pain and this and that, but you don't really hear about anything else. Is there a point in time when that becomes more available?
So the FDA is planning continued evaluation of COVID vaccines following the EUA. So we're going to continue to follow patients, and that data will, I don't know the exact plans, but we can anticipate data on longer-term follow-up for safety, more precise estimations of vaccine effectiveness, as well as, like you mentioned, some of the adverse events. So there are plans to continue that safety follow-up.
But does that information get published to the general public? I know at one point, for example, I think the AstraZeneca study had to be put on pause because of serious adverse event, and they didn't want to disclose what that was because of, you know, patient health reasons and things, or patient confidentiality and things of that nature. And I was just wondering, you know, at what point does that type of information get released to the general public?
You know, that's a good question. I don't know the exact details on that. These different surveillance systems have different ways in which they report some of the adverse events, but I can follow up on that for you, find that out.
I appreciate that. Thank you.
Sure.
This is Karen.
Go back to a question, Barbara, that you asked about. Find it. So you mentioned the phase 3 trials ending. FDA does not consider issuance of an EUA for COVID-19 vaccine to necessitate immediate unblinding of ongoing trials. And so we're actually going to kind of revisit that issue at the VRPAC meetings, how to address the ongoing clinical trials, the ethical aspect of that.
Yeah, because, I mean, we were told to enroll high-risk people, which are exactly the people that are going to be getting the vaccine. So I'm sure somebody's aware of this. I just thought I'd say that again.
Okay.
Also, I have a question. This is Karen. Is there going to be a prism that will be used for follow-up safety?
I'm sorry, Karen. You said will there be a what?
A prism that will be used for follow-up safety? What
you said, a prism?
What is the follow-up safety plan?
So on my slide I mentioned some of the systems that we're going to be using, and that was VAERS, VSD, which is the CDC. The FDA system is now called BEST, which is a surveillance system. which facilitates new and better data sources, methods, tools, and expertise. So we have these different monitoring systems that are in place.
Is the FDA PRISM database one of those systems? My question.
No, it's now called BEST. So it's kind of BEST is the kind of upgraded version of PRISM.
Oh, it's called BEST. Okay, and so will the public have access to that information?
So BEST does have a public-facing website. So I'm not exactly sure what the plans are for publishing data, but again, I can try to find that out for you. They publish a lot of studies, so I imagine that there will be some output from that.
Yeah, I mean, you know, obviously there's so much information. You know, I hear a lot of information from different sources, so it would be nice to have a place to get the proper information. One spot, you know, from the CDC. Obviously the news has gone crazy on this.
Yeah.
Thank you.
Sure.
Okay, anybody else have any questions for Ms. Marshall? All right, Ms. Marshall, thank you for your time. We really appreciate it. Dr. Kim, are you ready to go?
Yeah, I'm good to go. Thank you. Annie, I'm going to ask you to advance the slides for me, please.
Okay.
Next slide, please. So I'm going to take the next few minutes and provide you with an overview of what's going on in the Office of Infectious Disease and HIV/AIDS policy. And the first topic I'd like to cover is the National Vaccine Advisory Committee. Much like how ACCV makes recommendations to the HRSA administrator and thereafter to the assistant to the Secretary of Health and Human Services, the National Vaccine Advisory Committee reports or provides advice and recommendations to the Assistant Secretary for Health. And currently that the Assistant Secretary for Health is Admiral Brett Giroir, and we presently have for NVAC 2 charges, meaning we have 2 subcommittees working on different topics as they relate to immunization. And one of those is vaccine confidence, another is immunization equity, and the third is being proposed is being considered right now. So let me start with the one on vaccine confidence. The National Vaccine Advisory Committee subcommittee on vaccine confidence met and have developed a letter to the Assistant Secretary for Health on recommendations to build confidence in COVID vaccines to ensure that we have the full confidence by developing the infrastructure in place to boost vaccine confidence, specifically as they relate to COVID vaccines. And that's at the Assistant Secretary for Health. The vaccine on vaccine equity subcommittee, the work is ongoing. So we do not have a product for me to report out to this group on yet. As for vaccine for a charge that the Admiral Giroir has given to NVAC members related to COVID-19 vaccination. This is a third topic, or a topic that the committee members will be working on. It's a 3-pronged charge. Number one, what should and I'll just put this in the form of questions. So the Assistant Secretary for Health is basically asking, what should the department do before, during, and after the COVID-19 vaccination campaign to improve the confidence in these vaccines, in the COVID-19 vaccines, especially for the underserved communities, including racial and ethnic minority populations. That's question number one. Question number two is specifically talking about safety of vaccine in diverse populations. So the question is, what is the appropriate approach and timing of generating the needed data and how to proceed with the potential child vaccination. Question number 3 has to do with new and developing new and improved vaccines. So the question is, what lessons can we learn from the COVID-19 vaccine development and apply that more broadly to promote innovation and shorten timelines to increase availability of new products, meaning new vaccines for the public? Next slide, please. Oh, I'm sorry, stay on the slide. So the NDAC last met on October 16, and it was heavy on the COVID vaccine discussion, as you can all imagine. And the next committee meeting will be held tomorrow, December 4th, and at that time, the questions that I just outlined for you will be formalized by the ASH to the committee members. Next slide, please. The next topic that I'd like to discuss is the National Vaccine Plan. The National Vaccine Plan is in the current iteration is the 5-year is the current proposed draft iteration is a 5-year plan with an outlook on for review for publication in 2021 and to be subject to a total overview in 2026. It outlines the goals, objectives, strategies, and it also includes indicators and target ranges where those targets are available. Initially, we started this in 2019 and in the last quarter of 2019 with the initial call for public comments, and we received a number of comments on how to best approach the revision of the National Vaccine Plan. It was last published in 2010, and so it was obviously overdue, especially given the advances in vaccines and vaccinology over the past 10 years. It includes recommendations that have been solicited from the National Vaccine Advisory Committee and the Steering Committee for the National Vaccine Plan. It's basically composed of interagency vaccine work group. So that includes the federal agencies and identified here. So the FDA, NIH, and other agencies are part of this steering committee. We recently closed a public comment on the draft plan itself, and currently in the process of collating, reviewing, and adjudicating the public comments that have been submitted. We plan to release the report in its final form in the middle of January 2021. Next slide, please. And the last topic that I'd like to cover with this group is the vaccine safety report, which is currently in development. The vaccine safety report is a systematic review of adverse events associated with routinely recommended vaccines since the last report was published in 2014, and the one before that was in 2011. Excuse me. The vaccine safety report is a responsibility of the Office of Infectious Disease and HIV/AIDS Policy. And we commissioned the Agency for Healthcare Research and Quality, AHRQ, to actually perform the duties of reviewing and generating this report. And the current draft has been made available, and AHRQ solicited public comments on this draft, and that was closed pretty recently. And similar to the National Vaccine Plan, it is currently undergoing the review of the solicited public comments, and the submitted comments are currently being reviewed and adjudicated for incorporation into the final report. And the projected release for this vaccine safety report, this updated vaccine safety report, is actually we hope to get this out sometime in February 2021. So for this committee, that vaccine safety report may be of some interest, and I might take a minute to discuss the methodology or the systematic review itself. So back in 2014, when the last review was done and published, the current draft of the vaccine safety report identifies and reviews the literature that had been put out since 2014 to include in the overall bank of a review of the various literature articles. So it is an update, and the purpose of that is to ensure that the current literature on that report's adverse events as a part of typically as a part of the clinical trials are being reviewed and summarized in a reportable and digestible format. So that's the purpose of the vaccine safety report, and I will provide additional information for this commission as we get closer to the release date. That concludes my remarks for updates on OIVT activities.
Dr. Kim, thank you. Does anybody have any questions for Dr. Kim?
Yeah, this is Karen. I was wondering on that safety report, will that be accessible to the public?
The vaccine safety report will be released to the public in February. I hope it will be prepared by February, but we're working very hard to get the draft current draft in the final form for release for public consumption in February.
Fantastic. Thank you so much.
Where can we find, if I wanted to go look at the draft report, is that available to the public?
It was made available in the AHRQ. AHRQ is the primary body through which this report is being prepared, and AHRQ, I believe, made the report available for public comments through its website.
I was looking at its website. I couldn't find it, and I was going to maybe see if somebody would be able to email that out to us. I'd like to take a look at that.
Well, the public comment period has closed, so I am not sure if it is again available to the public for review.
To just look at the draft. I wasn't going to comment, but I didn't know if the draft would still be available for just to take a look at.
Website, it was not available, but I will look again.
Okay, I appreciate that. Does anybody else have any questions for Dr. Kim? Okay, it sounds like we're moving on. Thank you, Doctor. We appreciate your time.
Thank you.
Tamara?
Yes, I'm ready.
are you loaded and ready?
Yes, I am ready. So Annie,
All right.
Annie,
Thank you.
Could you advance my slides, the slides?
I sure can.
Okay. So at the request of ACCV, I'll provide an overview of the Countermeasures Injury Compensation Program. This program is administered by our division in addition to the CICP. So today I will talk about briefly about the Public Readiness and Emergency Preparedness Act. We call it the PREP Act. I will talk about the compensation requirements, the covered countermeasures, the eligible requesters, the benefits. I will summarize the process and share some of the data as of October 1st, 2020, and talk about how the program is funded. Next slide, Annie. So the Countermeasures Injury Compensation Program is authorized by the Public Readiness and Emergency Preparedness Act of 2005, and the PREP Act actually authorizes the Secretary of the U.S. Department of Health and Human Services to issue PREP Act declarations. And these declarations basically are what the Secretary uses to declare some type of public health emergency or threat, or when there's a public health emergency or some type of threat. A declaration is issued to provide liability protection and also to provide compensation for a particular threat. So, and also the PREP Act provides compensation, authorized the Countermeasures Program to provide compensation for serious injuries from the administration or use of a covered countermeasure. And as I mentioned earlier, the PREP Act also does provide liability protection to encourage the design, development, clinical testing, or investigation, manufacture, labeling, distribution, formulation, packaging, marketing, promotion, sale, purchase, donation, dispensing, prescribing, administration, and licensing or use of countermeasures. Next slide, Annie. So the compensation requirements. So the program is able to provide compensation to an individual who sustains a serious injury or a death based on compelling, reliable, valid medical and scientific evidence. The person has to have been administered or use a covered countermeasure, and it has to be, the covered countermeasure has to be used according to the stipulations in the declaration. Individuals have 1 year from the administration or use of a covered countermeasure to file a claim. So currently, the covered countermeasures sort of categories. So these, in all these situations, there have been PREP Act declarations that have been issued for these medical countermeasures against COVID-19, Ebola, nerve agent, and certain insecticides, and organophosphorus or carbamate, for Zika, for pandemic influenza, anthrax, acute radiation syndrome, botulinum toxin, and smallpox. Next slide, Amy. So who are the people that can actually file a claim with the Countermeasures Injury Compensation Program? So anyone who feels that they've been injured by a countermeasure. Also, their legal or personal representatives can file on behalf of an injured countermeasure recipient. Survivors of a deceased injured countermeasure recipient can file a claim, as well as the estate of a deceased injured countermeasure recipient. The benefits that are provided by the Countermeasures Program are reasonable, unreimbursed medical expenses. The program also provides lost employment income. There is a death benefit, and this program only pays after all other third parties have paid. So this is a summary of the process. So this program is purely administrative. So an individual actually submits a request for benefits package to the Countermeasures Injury Program. The package is reviewed by CICP medical staff to determine whether the requester is eligible for program benefits, including whether a covered injury was sustained. If the requester is determined to be eligible for program benefits, the requester is asked to submit additional documentation to determine the type and amount of compensation. that the requester may receive. If the requester is found ineligible for program benefits, the requester is informed in writing of this disapproval. Next slide, Amy. If the requester is filed entitled to benefits, the requester is notified in writing and a payment is issued. The requester may ask the Associate Administrator of the Healthcare Systems Bureau of HRSA to reconsider the program's eligibility or benefits determination. And then when that occurs, the Associate Administrator convenes a panel, and it's a qualified independent panel. It's convened to review the program's decision. The panel makes a recommendation to the Associate Administrator, who in turn makes a final determination whether or not to agree or disagree with the program's decision. And the requesters may not seek review of a decision made on reconsideration. Next slide, Amy. So as of October 1st of 2020, the program had, and this is in the history of the program, has had 489 claims filed. 446 of those have been for claims that are for covered countermeasures, and 43 have been for countermeasures that the program doesn't cover. The program has determined that 39 were eligible for compensation, and 29 received compensation totaling more than $6 million. 10 claims didn't receive compensation because they didn't have any compensable expenses or losses. The program is funded through appropriations that are provided to the U.S. Department of Health and Human Services, and in turn, the department provides funding to the CSCP, to the program. And that's to cover administrative and claims expenses. And then the program does have a website, and this is the link to the website, and also the program has a toll-free number. And this is the number for the toll-free number for the program. And the program is headed by Captain Dale Mishler. He's the chief of the branch that heads up the program. And I think that would be it, and right, that's the last slide. So I'm open to taking questions.
Thank you. I learned something new today. Thank you very much.
I have a question.
Sure. Yep.
What's the death benefit? How much is it?
So it varies because there is a standard benefit and there's an alternative calculation. So it varies by what a survivor or what a survivor chooses. So because we have to calculate it differently, yes.
What is that based on?
So there's one calculation that's based on the public safety officers benefits program, and so that amount for this year was, I want to say, about $365,000. So it would be, that's the amount of a death benefit. But like I said, there's another calculation that we could do based on what the person requests. So.
Is the fact that there's a one-year statute of limitations, is that going to be in some sort of a vaccine information statement that's given with the vaccine?
So I understand that there will be some type of vaccine information statement, and we have requested that this information be included.
Are these claims, when they are submitted, are they reviewed by a panel, or is it just a single person?
They are reviewed by our medical staff, just like with the VSCP program. It's reviewed by our medical staff.
Okay. And then who picks the qualified panel on an appeal?
Our associate administrator does.
And are those just doctors?
They are generally they're commissioned corps officers that have medical expertise in the area that's being reviewed. So yeah, so generally we're using commissioned corps officers. And for those who don't know, I mean, that's the public health service officers.
And how much money is there in the fund?
So that varies because, like I said, we request money from the department on a regular basis or an as-needed basis.
So if the bottom falls out and all of a sudden a bunch of people start having serious adverse effects from a COVID vaccine and it runs out of money, then what?
Then there would be a need to request an additional appropriation from Congress. But money has been appropriated to the department under these various COVID bills that have already passed, that have already been passed.
I gotcha. How much is that?
I could not tell you that because I do not know. I just know that the department, when we send a request to the department, they will send us money. So I don't know what the total amount is that's available to us is.
Too bad the Vaccine Injury Compensation Program can't do that.
Yeah, it's not. They were designed in total different legislation.
So I'm sorry for before I ask my question. I'm still confused on the third-party liability. Would that not be your employer or airlines if they make you take a vaccine to get on their airline?
So Karen, let me explain because it depends on. So Barbara had mentioned that airlines requiring people to have the vaccine before they get on a plane. That's different than an employer requiring their employees to have vaccines. So in the first situation, if a plane, if basically an airline is saying, in order to get on a plane, you need to have the COVID vaccine, then in that situation, because someone voluntarily chose to get it, then they will file a claim with our program, and we would actually pay even after all other third-party payers. So if for some reason they're injured, we would pay after Social Security, after Medicare, after Medicaid, after their health insurance, and then the program pays. Then there are some people who have filed claims in the past who don't have jobs or don't have health insurance, and so we would pick up those costs primarily because they don't have any other third-party payers. So it varies by the person's situation. In the case of someone who is like a nurse who's working in a nursing home and their employer says, you know, you're required to get the vaccine, then in that case, because it was required for employment, and if the person is injured, then they would have to file a workman's comp claim. But we've had situations in the past where people have filed and workman's comp denied them, but we would pick up and pay those expenses for them if they are denied workman's comp. But if workman's comp chooses to pay, then we would cover what workman's comp is not covering. So that's how it works.
Wow. Very complicated. So it seems, I'm hearing what I'm understanding from you, so I'm wondering, like, if the DMV says you have to have, you know, the vaccine to get your driver's license, where does that fall?
So Karen, we're always the payer of last resort in any situation.
Okay.
So it depends on what the person's situation is.
Okay, so hypothetically, if I have to get the COVID vaccine to get my driver's license or an ID, I first go through my insurance or my Social Security and then go after the COVID measures program, or the calendar measure program. It's very complicated.
No, it's actually not. It's not actually not very complicated because we do walk people through the program, and we actually help people to navigate the program, and we exactly let people know what's needed. We let people know, you know, where they are in the phase of their review and in the phase of the benefits determination. So it's not, and we're clear in the documentation that we provide to them. So we're basically walking people through the process. It's not a legal process. It's not like the VICP. It's an administrative process that we are communicating with requesters on a regular basis and letting them know what needs to be filed and when, and we're communicating with them directly.
And so what Mr. Momo said earlier is that, well, we know that the lawyer fees are not covered, and there's no pain and suffering, and there's no lost wages. Is that correct?
No, there are lost wages. So they can get paid for unreimbursed medical expenses, lost wages. They can get lost wages.
Okay. What did he say that, I thought, okay, so I thought he said that there was no, you can get lost wages, but not any personal pain. Is that, what is that?
The program does not pay pain and suffering.
No
That's
pain
true.
and suffering. Okay. Thank you so much.
Tamara, I have a couple more questions.
Yes.
So under the Vaccine Injury Compensation Program, the statute itself prohibits a lawyer from charging a client a portion of the recovery. Is there a similar prohibition under the CICP?
So the CICP is not a legal program. It's an administrative program. And so because the intent of the program is to be administrative, the legislation did not permit attorneys' fees and costs to be paid because it's not a legal program. It's not, the CICP is communicating directly with requesters. We're not using an attorney like with the VICP. With the VICP program, the DOJ is representing HHS, and then Petitioners Council is representing them, is representing petitioners. That's not how this program works. It's requesters are submitting documentation directly to the CICP staff. CICP staff are communicating directly with petitioners and walking them and helping them navigate through the program. So it's not a legal program, and it's not attorneys that are representing HHS to the requesters. It's actually our staff who are communicating with the requesters on a regular basis. So that's how the program was designed, and so that's why there is no stipulation for attorneys' fees and costs to be paid, because the intent wasn't for attorneys to be involved.
Yeah, and I get that. But my question is just a little bit different.
Okay.
If, for example, I suffered a COVID vaccine-related injury and I wanted to go hire a lawyer, would there be anything that would prevent me from paying them a portion of my recovery from the CICP, for example? Under the MVICP, that would be not allowed. The statute says a lawyer cannot take a portion of the client's recovery. But is there a similar prohibition like that for the CICP?
So if a client chooses, if a requester chooses to have an attorney, then it's up to them to pay the attorney.
Okay, I got you. And the reason I asked that is because you had that slide 6 that says a legal representative on behalf of the injured person could file a claim, and it just made me kind of wonder.
And generally those are situations where you have someone who may be seriously ill and they can't, or you have parents filing on behalf of their children, or sometimes you just have other family members filing on behalf of other family members. So that's what that's intended.
Have there been any claims for COVID-related, vaccine-related injuries yet?
So there have been claims filed alleging injuries from COVID-covered countermeasures. Yes.
How many?
We still work with our FOIA office to determine what we can share, what information we can share.
So that's not included in these numbers on here, I take it?
Exactly right.
Of the 39 claims on your slide that have been determined eligible for compensation, how many of those were vaccine related? Do you know?
The majority of them are vaccine related.
And of the 6 million that's been...
I'm sorry, these were these claims were filed for primarily back in 2011, 12, with the H1N1 pandemic. Right. Yes.
Of the 6 million that was paid out on the 29 claims, I mean, was that? It just seems like a small amount of money, but yet a large amount of money when you're talking about only medical bills, only lost wages, and the fact that this is really a secondary payer program. Was that primarily medical bills or lost wages, or just all of the above, death benefits?
It was a combination of all the above. And some people would have gotten medical expenses and lost employment. Some of them were, would have gotten annuities for payments into the future. So it just varied. It depends on the person's situation.
I'm sorry, I don't mean to dominate this conversation. Please jump in.
Oh, no, I just wanted to ask, did you say that there's been already complaints filed on vaccines, even though vaccines not available yet?
No. I said COVID and covered countermeasures. I didn't say vaccines.
Got it. But I thought he asked about vaccines. But so you haven't had any for vaccines? Okay.
Right. I haven't had any for vaccines. I thought John's question was of the ones that were on that slide, were they predominantly for vaccines? Wasn't that your question, John?
Yeah, I had two questions. The first question was, have there been any COVID-related claims filed?
Yes, but they're not for vaccines.
But not for vaccines. Okay, and then my second one was, of the 39 claims that are on your slide, how many of those were for vaccines?
The majority of them that are on the slide were for vaccines.
So what are people, I mean, just generally, I know you can't get into specifics, but are people filing claims because they just got COVID?
So that's, like I said, we're still talking to our FOIA office about what we can say.
Very likely. That sounds right to me.
Does HRSA plan on releasing that information at some point? I mean, I'm assuming that's what you're talking to FOIA about, right?
We're talking to our FOIA office about it, about what we can release, right? Because, of course, we have to protect people's privacy. And then the other thing to consider, too, is that people post things on social media nowadays. So you could potentially have a situation where they say someone posts on Facebook, oh, I filed a claim with the VICP and it was for this, or the CICP and it was for this. And if I release data, then you could potentially connect the two. And so that's what it's a different world now. And so we have to just take all of that into consideration before we're posting information about claims that have been filed.
Can I go? I have a couple questions. I don't want to interrupt you, John.
No, go right ahead, please.
Okay. Well, obviously, I think everyone's fascinated by this. How is the awareness of this program being raised?
So my understanding is that during the clinical trials, information is being distributed by the various organizations that are conducting trials. That's one way that I'm aware of, and sort of the primary way.
Oh, okay. And then I know we just kind of talked over this, but what's the transparency of the percentage of the awards versus the petitions? So, because obviously you don't have any vaccine awards in process, but and the attorney fees aren't going to be paid for in that process, but will we be able to follow the compensation, or we're not clear on how that's going to work? Is that what you were just saying?
So like I said, we are having discussions about what information we are able to release about the program.
Because they are released in the national, in the ICP, obviously, as we all know. So, I understand that there are very few different programs that you've been explaining. So it is very interesting.
Do you have any stats on how many denials have been appealed?
I would have to get that information, John. I don't know the number offhand.
And then the next, taking it one step further, how many appeals of a denial were successful versus unsuccessful?
Okay.
So my understanding is obviously you have to have an attorney. Do you have to have an attorney to apply for the countermeasure program?
No, you don't.
Okay.
You don't even have to have an attorney to file for the VICP either. Some people file pro se.
Okay.
But this program is administrative. It's not a legal program. You don't need an attorney. They literally, it's a form you complete. It's not like with the VICP where there's a petition, almost like a brief that you complete. This is a form that you complete. It's a form. And, submitting medical records. Are there any other questions about the CFCP?
Thank you. I'm sure I'll have other questions, but that's really, really helpful. I appreciate that. Thank you.
So since I still have the floor, I'll take this opportunity to thank you, John, for your leadership with the ACCV. I have truly appreciated working for you and appreciated your leadership over the last, I guess, year or so. And we will miss you, but thank you for all that you've done. And also, I just want to make the other comment that the program does appreciate the ACCV and all that you all do and the recommendations that you make. And even though it may seem that sometimes your recommendations aren't being implemented, they actually are used for other purposes. Because at times, congressional staff have mentioned your recommendations in activities on the congressional floor, or others have used your recommendations and approached us and say, oh, well, the ACCV made the recommendation. So your recommendations are used, even though it may seem like it's not, but they are helpful to the program, and they are viewed by others. So I'll just say that part. So, no, you are valued, and we appreciate you all.
Well, thank you.
Thank you.
Well, can I have about 30 seconds?
Yes, I'm sorry. I'll yield the floor to you, John.
I just want to tell you, Tamara, you and Annie have done just a super fantastic job keeping this thing moving in the right direction, and I really appreciate that. Coming into this, I had no idea what to expect, and you guys have made it really easy on me, and I appreciate that. Karen, it has absolutely been a pleasure to work with you. Barbara, you as well, and Bill, I regret that we didn't have enough time to really get to know each other very well, but and everybody else as well. I really appreciate it. Thank y'all.
Yeah, I vote to keep you.
I think we should vote on keeping you for 3 more years.
Yeah, I mean, what are we supposed to be? It's going to be down to what, 3 of us again? I mean, that's not a party.
So on that note,
I'll be here in spirit.
So on that note, Barbara, that's the other thing I want to mention is that we are moving nominations through the process, and hopefully we will have additional members by March, by the March meeting, if not before, hopefully. We're working on it.
Awesome, thank you.
So, but we still, like I continue to say, we continually take nominations because, we've had members to resign, so that's what we do. We want to continue to accept nominations on an ongoing basis so that we have them available if the need arises. But yes, so we are working on it. We're diligently working on it.
Thank you. I really appreciate that, and all the work everybody in this committee does, because it is true, it's not easy to come log in for a whole day and push everything aside. So,
and we really appreciate that you all do that. We
That's
know that you're
to you guys
people.
too. Thanks. And I know we're not an easy group, so especially thank you to you guys.
I guess on that note, we talk about future agenda items, and then we need to open up for public comment. Is that right?
Sure, you can do it that way. It's actually the reverse on here, but you can do it that way. That's fine.
I'm happy to.
You're still the chair.
I'm pretty flexible. I can do it any way we want to do it.
Okay. Yeah, it's up to you.
Well, then let's open it up for public comment, and then we'll stick with the agenda.
So, operator, can you open up the line for public comment?
At this time, if you would like to make a public comment, please press star 1 and clearly record your first and last name. Again, if you would like to ask a public comment at this time, please press star 1. One moment, please, to see if we have any comments. And our first comment comes from Jimmy Hoggs. Your line is now open. You may ask your question or make a comment. Excuse me.
Yes. Thank you for listening to me again. This is Jimmy Hodges. I spoke with y'all this morning about my pneumococcal polysaccharide vaccine injury. And there was a point that I missed telling you this morning. I got this off the I guess it's HRSA website, HRSA, and it says that pertaining to my vaccine injury, that CDC recommends routine how do you pronounce it? Pneumococcal polysaccharide vaccination for one of the three categories is people 2 through 64 years old with certain conditions, certain medical conditions. So the vaccine injury I received is a vaccine that is given to children. And so I have a question and I have some suggestions. Hopefully, well, my question, and another thing, the lady from VAERS, she says there's no way my vaccine injury should not be covered under the program, under the SERVA program. And so my question is why haven't they ever considered including my vaccine in the program? And in my opinion, they should include all vaccines because the biggest percentage of them are related to vaccine administration, not the vaccine itself. In my case, I had a major injury. They put most of the vaccine inside my bursa sac. So I was almost about 98% paralyzed within 2 hours. I could move my arm like 8 inches from my side in less than 2 hours from the vaccine. And then the way doctors are, you're left out hung to dry because doctors will back each other up. They waited 17 months to send me for a MRI, kept doping me up with cortisone shots. And then by that time, the MRI showed a complete tear in my supraspinatus tendon. And so I had major surgery. I'm still trying to get over it. And this was 2.5 years ago. And so my question or suggestion is I wish that they could do something to get my vaccine covered, if not for me, for the future people, and look into covering all vaccines that are related to vaccine administration. Because a lot of people are out here suffering, and it's mostly the adults. So anyway, that's my suggestion. I don't know if you got any answers for me or what I could do, but I've had to pay the doctors cut me off after the MRI. They cut me off making any payments, so I've had to pay for my surgery, physical therapy, and then all the pain and suffering I've gone through for 2.5 years and still going through it till it heals up completely. So I appreciate your time and would like to hear your comment on that as far as any suggestions or what's in the works or what you may could do for me. And I can leave my name and number if you'd like, or email you if you tell me where to email.
I don't think you want to give your phone number out because this
right.
is a public forum, and you might have everybody from all over the country calling you.
Yeah, you're right, John.
So, Mr. Hodgins, this is Tamara Overby. You can email A. Herzog, HERZOG, at hrsa.gov with your question.
Okay, it's on your website, right?
I'm sorry, yeah. I'm sorry?
Okay.
Yeah, so if you email her question, because we can definitely get back to you and explain to you specifically why the polysaccharide vaccine is not covered, but the conjugate vaccine is. So we can explain that to you. But yes, if you just email her.
I've talked to quite a few people and haven't been able to get a logical explanation.
We can explain it to you, sir. So if you just
named Dale, named Dale, he was almost rude, just saying there's no way possible that anything could be done because it would take an act of Congress, and that's not going to happen because they would try and attach all kinds of other bills to it. So I haven't found any help through an attorney or a, because the family doctor, which did not know anything about vaccine injuries to start with, he he made a statement to me that, and I guess he hooked me up with an orthopedic surgeon. But anyway, he said the vaccine did not cause my injury, which is totally wrong. I got 8 years of chiropractor records where I've never complained about my shoulder for any reason, ever. So anyway, I got a solid case, but you can't go against doctors that are just being dishonest. So that's what people like me are going through. They can't find attorneys. There's too much litigation, too much cost, and all that. And they don't want to deal with it. So I'm just throwing some information out to y'all, so you know for somebody going through it firsthand, what people like me deal with, and they're going to get no results probably. Okay, go ahead, Annie.
Thank you, Mr. Hodgins.
Okay. Well, have y'all got any other comments for me? Any suggestions or anything? Or maybe you could get into a little bit of why the pneumococcal polysaccharide is not covered.
So it's not covered because it's not recommended for routine administration to children or to pregnant women. That's why it's not covered. The pneumococcal conjugate.
You go on the website for HRSA, it says what I just read to you in print.
No, it's not recommended for routine administration to children. It's recommended for administration to high-risk children, which is that's the difference. So that's why it's not covered.
It says with certain medical conditions, it says CDC recommends routine pneumococcal polysaccharide vaccination for, and the second item is people 2 through 64 years old with certain medical conditions. So if you're saying the certain medical conditions is why it's not approved, but it is routinely recommended for children. It says it right here. The CDC recommends routine pneumococcal polysaccharide vaccination. They should change their wording because it says routine for children 2 through 64 years old.
So like I said, if we will get back to you if you just email Annie Herzog.
I've tried to call her and left a message for her, and they put Dale on me. Dale won't give you the time of day. Hate to tell you. But I'll reach out to her again, but I'm not getting a logical explanation why it's not covered. You know, because it says it right here from HRSA on their website. Are you familiar with that?
Yes, yep.
Okay, well then you said that it says people 2 through 64 years old, which is children, but it does say with certain medical conditions.
So, Mr. Hodgins, we will definitely reach out to you and speak to you directly about the situation, and so we appreciate your time, and we need to move on. So thank you.
And another thing, well, let me say just one last thing. Why I don't understand, like the other question was why they haven't had a lot of discussion and try to get the vaccine injury compensation fund to include all vaccines if they can, and protect the older people too that are getting injured by the vaccine administration, which is the biggest injury. So, do you have any comment on that? Why they haven't ever tried to do that?
So there have been discussions in this group about potentially covering all adult immunizations. So those discussions have occurred. That would require a congressional action to change the law to include those vaccines. So yeah, that's what I can say about that. It's been discussed here, but it will require like some congressional action for it to happen.
Okay, well, maybe if you throw those numbers in there in front of them, like the 99% of server claims are adults, you know, and then the over 50% of the injury claims are server, maybe somebody would listen. So I appreciate y'all's time, though.
Thank you.
Okay, bye.
Our next public comment comes from Teresa Rangham. Your line is now open.
Thank you. My name is Teresa Rangham. I'm the Executive Director for the National Vaccine Information Center. Our mission is to prevent vaccine injuries and death through public education and to defend the informed consent ethic and U.S. vaccine laws and policies. As I mentioned earlier, our co-founders worked with Congress to draft and pass the National Childhood Vaccine Injury Act of 1986. I'd just like to sympathize with the previous gentleman. When the law was enacted, there was no adult vaccine schedule, or it probably would have been included. Only routinely recommended vaccines that aren't for special populations, that are for every child, are covered under the Act. And I think that's what Ms. Overby was trying to put out there. In any case, in listening to today's presentations, I just want to thank the ACCV for their thoughtful deliberation and for providing a forum for discussion of all viewpoints. This is important, particularly at a time when we see censorship of any discussion of vaccines that steps outside the one-size-fits-all pro-vaccine scenario. Briefly, I also wanted to provide some historical context on some of the presentations today with regard to the NPRM position of removing automatic addition of vaccines that are routinely recommended by the CDC for children to the federal vaccine injury table. The law is really clear on this. Even though the Secretary is proposing removal of automatic addition to the table, if the NPRM goes into a final rulemaking, the Secretary will still be required to add vaccines to the table that are routinely recommended for children no later than 2 years after the recommendation from the CDC, and that's per Section 300 AA-14. Though I'm not an attorney, it seems clear that the bottom line is that additions to the table are mandated. I believe that the 2 years was crafted into the law and links back into my presentation with regard to the research mandate. The hope was from our community that we represent and our co-founders work with legislators who crafted the law, that as vaccines were developed and recommended, that an equal investment would be made into research to identify the mechanisms of injury so that they would be included with the vaccine onto the table to expedite vaccine injury compensation. Instead, because that investment has not been made and the research mandate fails to be fulfilled, it's become a lengthy adversarial process, and this contributes to vaccine hesitancy. However, it seems that the Secretary is not going to be able to prevent the addition of vaccines to the table without a congressional act. With regard to vax-on-vax studies, I just wanted to mention the IOM stated pretty clearly that the schedule has not been systematically reviewed as a whole, and that is the main concern of parents today. It also issued a report on access to VSD data by independent researchers to replicate and confirm research findings produced by the government using the VSD. Replication of findings is the gold standard and necessary. Public trust issues were also cited by the IOM in the same report, and there's also a question as to whether or not the VSD is statistically powered to conduct such a study. NVIT has for almost 40 years supported the creation of an independent agency to monitor vaccine safety and oversee vaccine safety research, as well as supporting a large prospective study to compare the long-term health outcomes of highly vaccinated children against unvaccinated children. Should a vax-unvax study be undertaken, such a study must be conducted by independent researchers, as all agencies under DHHS are inherently conflicted in conducting such a study, given their involvement in the vaccine enterprise, starting from patenting right through to approval and direction of vaccine use, distribution, and then determining who gets compensated for what injury. There is no independent safety and monitoring of the U.S. vaccine system, and these inherent conflicts of interest that allow a fox to guard the henhouse scenario is demonstrated by this latest NPRM and contributes to vaccine hesitancy. While ACCV cannot put forth funding in such a study, they can and should fulfill their legal obligation under the Act to make research recommendations as provided by the Act. The creation of a research work group to explore what research is needed to fulfill the 1986 mandate for research and invite members of the public to assist in assessing such a charge to help frame recommendations and report findings back to the ACC for their consideration could be formed. These types of work groups are formed under the National Vaccine Advisory Committee and also under the Committee for Immunization Practices, and they help these committees form their recommendations under their own charges. Commissioner Fahoud had asked a question about the role of the ACCV in this sense, and it is provided for under the 1986 Act. And the Secretary also has an obligation to fulfill the ongoing research mandate. ACCV research recommendations play an important role in documenting how to close existing gaps highlighted by the IOM reports, and were part of the spirit and intent of the 1986 Act that continues to live on in the language of the Act today. ACCV can also, per the Act, recommend other avenues to raise awareness around the existence of the VICP as current efforts continue to fall short, as noted by federal reports. Per the Act, the ACCV can also survey what federal, state, and local government processes have been put into place to better capture vaccine adverse events, which is much needed given the passivity of VAERS and it capturing only a fraction of vaccine adverse events. Under the law, the ACCV can also petition to add injuries to the table independent of current NPRM efforts. With regard to a change in administration, this might be an avenue to investigate. I want to say that I'm appreciative of the language that was adopted today with regard to the VIF and clarifying the deadlines that are required in order to qualify for compensation under the VICP. With regard to the lack of commissioners filling positions within the ACCV, MVIC has offered up nominations, and we assume that other nominations have been submitted by other individuals and organizations. It is unknown why or what the status of some of these nominations are. However, open positions may not necessarily be due to the lack of applications to fill them. With regard to COVID-19 vaccines and the MVAC's efforts to assure confidence, we note that the engagement of the vaccine safety and informed consent community has been excluded from these confidence-building efforts, and they were also excluded from similar engagement efforts in the review of the 5-year plan. The plan focuses on vaccine innovation and development with no equal investment into vaccine safety science and does not support the human right of informed consent, which includes refusal of medical interventions. We would also note there doesn't appear to be involvement of the ACCV within MVAC efforts to build confidence or the plan, so vaccine injury is a concern of the vaccine hesitant. The AHRQ review that was published is also subject to the same conflicts of interest I mentioned earlier, and is not a substitute for the role that the National Academies of Science have played in informing and reviewing vaccine injury. I want to thank Tamara Overby for presenting the overview on the CICP. I think the public is very curious about this mechanism, as well as what appears to be a lack of transparency in what can be said about the program. With regard to perhaps airlines or other agencies restricting freedom of movement by policy or by refusing to issue something like a driver's license, it would appear to be a violation of civil and constitutional rights. Again, I want to thank everyone today for their thoughtful deliberation of these concerns. It's disappointing that the Secretary is exercising authority in what appears to be an abusive manner rather than call on the ACCV to examine evidence in a thoughtful and deliberative manner and give full consideration to an informed recommendation prior to exercising rulemaking. I hope the ACCV will consider reviewing their function and abilities within the Act to move forward more effectively in fulfilling their role as envisioned in the Act. There are longstanding concerns from the community NBIC represents, the vaccine-injured, safety, and informed consent concerned community that could be addressed by the Commission. Thank you so much for all your efforts, and thank you, Commissioner Howie, for your service, and everyone today who listened.
Ms. Rangham, thank you for your time. We appreciate it. Thank you for your comments. Do we have any other? Do we have any other public commenters?
I am showing no further public comments at this time.
Okay, are we ready to move on to future agenda items? That sounds like an overwhelming yes.
Yes.
I had mentioned, and Tamara, obviously you had emailed and said that this would be more appropriate for future agenda items, but obviously you guys are going to need to select a new chair.
I would like to put my name in. Of course.
You can also choose to wait until we have more members, too. That's the other option.
If we were to vote today, I would vote for Karen, but you guys are the ones that live on and not me, so I leave that up to you guys.
Mm-hmm. How long does the chair hold the position?
So generally the chair usually has held the position from when they take the position until when it's time for them to go off, unless they choose to step down before their term ends. So it's not in the charter, our charter doesn't stipulate the time, there's a term limit or a time frame for the chair to serve. So, and then that's the other thing. So Karen is currently the vice chair. So then that would need to be, if she does become the chair, then a vice chair would need to be selected. So that's the other piece of this too. And as I mentioned, the intent is
William, I have 2 years left.
I'm sorry, say it again?
I have 2 years left as the ACCV commissioner. Just wanted to add that.
Yeah. I mean, I would be happy to vote in favor of Karen. And in terms of a new vice chair, I would lean toward waiting till we have more members.
Barbara?
I don't know why I thought that there were going to be more people to select out from. I would also be happy to throw my name in there to be chair, but I agree with the last comment that maybe we should wait until we have more members, because right now, what are the options, really, the 3 of us?
Yes, at this point.
And so who can nominate only the 3 of us?
Yes, at this point.
Huh.
Well, John is still officially a member too. So, well, I mean, as far as vice chair and chair, it's the 3 of you all until new members are appointed. So yes, it would be limited to just the 3: Karen, Barbara, and Bill.
And can you explain again what the role of the chair would be then?
To do exactly what John was doing, where you lead the meetings, and you're meeting with Annie and I before the meetings to help plan for the meetings. And because what we do, Annie and our group do all the logistical work for the planning of the meeting. It's just we consult with you all regarding the agenda, the topics, for the chair and the vice chair. We do both, and then leading this meeting. And then ultimately, too, when you have recommendations, basically you are reviewing, modifying recommendations and signing them. That goes to the secretary, along with the vice chair.
Yeah. Well, I mean, I think it would be wise for us to wait until we have all the members, because I'm afraid that if either Karen or I took this position now, there's really just 3 of us. So it doesn't seem right in some way for me, but if it has to be between the 3 of us, then yeah, I would throw my name in there too. But I would agree with the last person saying that we wait till we have all members.
Tamara, can we do that? Can we wait till the next meeting to see if we have more bodies and make a more informed move?
Yeah, absolutely. Yes.
I would prefer that.
Me too.
Okay.
That sounds perfect. I guess the last thing that I would leave you guys with is, there was a discussion earlier today, I think it was Mr. Milmo that had suggested something that I had brought up in the work group, which is this concept of potentially the retention of a independent third-party consultant who could review the processes that are involved. And Bill, you understand obviously probably more than Dr. Pahud, but there's attorney-client privilege, attorney-work product issues that kind of interwoven between all of these little departments. And so I had thought, maybe the concept of an independent third-party consultant who could come in and act in that role without, violating any type of attorney work product or attorney-client privilege might be something to consider. And I still think that might be a good idea. But at this point, I'm going to sign off and leave that up to you guys.
Thank you, John.
And I don't know, is there any other future agenda items that we need to discuss?
I had something that I just wanted to bring up briefly. I brought this up before, and I think that maybe we need to revisit it next year. But it's looking at the sudden infant death syndrome that has been reported to VAERS. In 2016, there were 15 deaths that were reported. 2017, there were 19 deaths. In 2018, there were 15. 2019, there were 11. In 2020, there have been 5. And I don't know if theirs is on the same calendar as the Vaccine Injury Compensation Program, but that's dramatically different. And I think it's something that would be, that maybe we should revisit next year as we get more stats available.
So Karen, so what are you suggesting that the ACCV do about this?
I mean, I think that part, they're just reporting that, a third of the injuries of kids cases happened this year, and at the same time, people aren't receiving their vaccination. So I guess I'm just wanting to put that on the table as something that possibly, we should be looking into, because it's a big change. It's a dramatic decrease in kids cases being reported, and there are, at the same time, people aren't getting vaccinated. So I'm just throwing that out there. Obviously, it needs a lot more information, but it's a big number. I would think it'd be part of our purview to make sure that, to look at these studies and to look at this information.
Anything else? Sounds like we may be finished, guys.
Yeah. All right, John. Thank you.
All right, thank y'all.
Thanks, everybody.
Thank you. Bye-bye.
All right, y'all have a great day. Bye-bye.
Best to you, John.